say this, he'll say it as long as all of you finish by lunch. If you don't say it, then we can carry on beyond lunch. There's a simple structure. I'll just make a request. I'll just take 2 minutes at the end, whenever. Yeah. Insisting on that mandate, no? Yeah. Because
Unmuted. Muting is here.
They can learn. So if I want to mute it, then they can.
what happened in item 9 there?
In BC,
In which
PDF page 849,
were you preparing for? Which side are you on? Same, I have
840, volume 5.
Preparing for one of the petitioners or what?
849, part of Bir Singh.
PDF 849.
Correct. Para 28.
So it's in this matter.
It's only for this, only for the sequencing. But our name of, my name and learned AG's name is not there. Because they were not aware which side of the, maybe subject to your lordship's permission, my lord, address your lordships for very brief after Mr. Sibal concludes. I won't take more than 10 to 15 minutes.
Okay.
And
I guess the AG will take the same amount probably.
I think so, my lord, because learned advocate general has substantially, my lord, very ably, my lord, assisted
Fair.
your lordship.
Mr. Sibal, then
Let's see.
that's fine. Mr. Either the attorney or Mr.
Yes, sir,
whoever
the learned attorney is online.
And then we will hear Mr. Venugopal.
I would take half an hour, my lords.
Certainly.
Only half an hour.
Just one request, not for Telangana, but the name is not going to Lord, I'll just take 2 minutes.
Certainly, Mr. Pudasa. Mr. Luthra, just make sure, Mr. Luthra, between your other work, just make sure you are here at the right time, though.
I will not, look, I have very little work.
Oh.
I already raised the issue of estoppel against him, my lord. I already discussed.
That you will have to learn from Dr. Singhvi.
But I've told Mr. Mehta, he and I, yin and yang, we have to be together with the same face at the same time.
That's true.
Also, on a lighter note, that only female counsel arguing on the vein of affirmative action, may I request for?
Yes, yes, Shraddha. And be prepared for a volley of questions as well. All right.
Your Lordship, I have a similar request for State of Haryana also.
Yes, ma'am, of course. A minute, 2 minutes, we'll give everybody. No, but something new, okay? Not whatever people have already.
Already the learned AG and Mr. Farasad have already argued for you.
We'll suggest is, honestly, what we'll suggest is after the main arguments are over, the interveners may give us just a page of submissions. Give the page of the submissions to the nodal council. Nodal council will put it together and email it to us so that, they remain on the record. So I think that's the way.
I think, my
we should
lord,
go
other
about it.
side also would get some.
Yes, they will get some time.
Yes.
All right now.
Council was hearing me would not come in person. But I may be permitted to address your lordship on a short issue.
I just said that, therefore you give us on a page your submissions and give it to the nodal council.
Address your lordship for 5 minutes. 5 minutes.
Give us on a page. Then it's a matter of record. That's the reason I'm saying that.
I will do that. I will.
Yes.
Yes.
Share it to the court martial.
Yes, Mr. Apple. Now, if everybody mentions their appearances, we'll be cutting down on the time available for concluding the matter. So we'll hear everybody. Don't worry. Yes. You be here, Mr. Counsel. Be here. We'll hear you. You said you are for the original petitioner. No problem. In Chennai.
At the outset, Mullahs, I'm not going to repeat any of the submissions that have been made by my colleagues. Mullahs, I look at it from
Yes.
In the 21st century, Millers, we are looking at issues of equality, inequality, issues relating to how we ameliorate the conditions of those who have been sidelined for centuries, who have been humiliated for centuries, who have been ostracized for centuries. I don't think we can ever imagine how they were dealt with in the context of the caste structure that prevailed. So, Malads, I think that the constitution makers in 1950 realized this. That is why the notification was issued in 1950. And they also realized that this is not going to stop. Because they gave the power to Parliament, but this is an evolving situation. They gave power to Parliament to deal with the matter. And it's unlikely that this is going to end very soon. It is in that context, Malath, that we must look at this matter. And what we can do, quite apart from reservation. For Malath, the two basic assumptions that Chanaya made, which were wrong, is number one, they considered the scheduled castes in the order as a homogeneous group. They assumed that this represents a homogeneous group. And I will demonstrate to your lordships that that assumption is based on no factual data. That assumption is based on no analysis of that data.
What they hold is that once they find the place in that particular group, then they are all part.
Homogeneous. What's the basis of that? In fact, heterogeneity is inherent in that.
Actually, the homogeneous nature of all the entries is for the purpose of designation.
Yes, absolutely.
They are homogeneous in the sense that each one of them is a scheduled caste. But your argument is that there is no homogeneity either in terms of the sociological profile, economic development,
Correct.
social advancement,
Absolutely.
educational advancement.
Absolutely. So that assumption in Chanaya was wrong.
Common factor is social and social backwardness, social and economic backwardness. But the degree may vary from one
Absolutely.
entity to another entity.
Absolutely. So the assumption of homogeneity in Chanaya itself is constitutionally flawed. That's the first mistake Chanaya made. The second mistake Chanaya made was that it correlated the presidential order with reservation. These are the two assumptions on the basis of which Chanaya was rendered. Neither of these assumptions is valid.
Because the designation is for the purposes of the Constitution.
That's correct.
It's not only for reservation, nor is it coterminous with reservation.
I'll go a step further. It has nothing to do with reservation. Well, that's the designation of this class has nothing to do with reservation. Reservation emanates from the plenary power of Parliament, which is in 16(4) for the purposes of employment.
Because Indira Swani says that it can be done even by executive instructions.
But now not anymore, Malaj. Because now it's Parliament has to make a law, Malaj.
What?
Now Parliament has to make a law to change the schedule,
Reservation, Indira Swani goes on to say that it is not necessary that there has to be legislation. It can be done even by executive instructions.
Maybe so, Malaj, but that is not part of the notification. But that's nothing to do with reservation. My point is, Malaj, you are assuming
that may not be correct, because if there is a reservation for scheduled caste, so unless that particular entry finds in the place in the presidential order, that person from that is not entitled to
I just demonstrate that to your lordships, wherever they wanted to give reservations, they have given it. Then reservation is part of 16(4) itself as
Yeah,
far as employment is concerned.
It's a necessary but not a sufficient condition.
Correct.
Designation under Article 341
Yes.
is a necessary condition for reservation, but it is not sufficient in itself.
Correct.
Because having been designated, there is still an enabling power which is conferred upon the parliament, or for that matter, as brother says, on the executive.
Yes, but it's the union or the parliament, Manoj, but the order itself has no reference to reservation, and I'll show that from the chapter itself. Manoj, first of all, let me go to the first point.
Yes.
And then I'll come to the second point. These are two assumptions I want to deal with immediately. Now kindly come to PDF. This is volume 4, PDF page 1381. Oh, sorry, 1386. The running page is 1381, volume 4. I'll quickly, Manoj, demonstrate that here also.
Yeah, page 1384.
Manoj, sorry. 1386, volume 4. My lord has it? Your ladyship has it? Just 4 minutes, volume 4. Or 10. It's okay. Volume 4, page 1386, Manoj, PDF 1386. We're looking at Punjab, Manoj.
Mr. Kasibal, just give me just a second.
Lordship has that?
Just one. Just one.
Sorry.
Volume 4, right? The
Yes,
main
volume 4,
yes.
1386.
Yes,
You have that chart now, Manoj?
yes.
Now kindly look at item 38 on the right-hand side. Mochi. We all know, Manoj.
Yes.
Now look at 34. Sapera. Sapela
I think
is
snake
snake,
chamas.
snakes.
Snake chamas.
One has nothing to do with the other. Look at Manoj's Bazigar. He indulges in acrobatic feats. Then Batwal Malaj. Actually belongs to the Rajput caste. Malaj is normally a watchman. So what you have an agglomeration of various castes which are put together who have been humiliated for centuries. The heterogeneity is clear from the table itself. I can go on, Mala. There is one Gagra, which has only 268 families in Jagraon in Ludhiana. There is a Nut, which is an unskilled labor. The Koli is the hunter and a butcher. The Sasi Malads is a criminal, comes from that class.
Kori would be fishermen.
No, but originally came as hunters and butchers. That is item Malads.
So there is heterogeneity in
91.
terms of the pre-existing occupation,
That's right.
in terms of the resources or lack of resources,
Exactly.
in terms therefore of all the indicators of backwardness or development.
Exactly. So therefore they are put in one
Income,
class.
Income, social status.
Yeah.
The status of every caste may not be the same in the social hierarchy as well.
Exactly. Exactly. So that
Between them, some may be a little more advanced, some may be a little
Correct.
less advanced, people may be particularly underprivileged.
Correct. Absolutely.
In terms of other indicators like infant mortality, maternal mortality, fertility rates, which sort of define, broadly speaking, whether there has been progress in the social indicators.
Absolutely. Now that assumption was made by a observation of Justice Krishna Iyer in Thomas. And that's at page 135. Sorry, para 135, but let me give you the page. Volume 5, page 84. ADF 84. Yes.
Did Justice Krishna use the word homogeneity or?
No, he said, he doesn't use the word homogeneity at all, Malad. I tell you, Lordship, what he said. Just have a look at volume 5, PDF 84. And this is, Malad, in fact, quoted by Justice Hegde. And then he comes to the conclusion that they are one class. Now just see, Malad, that.
Yes.
May I read it, Malad?
Yes.
We may clear the clog of Article 16(2) as it stems from a confusion about caste in the terminology of scheduled castes and scheduled tribes. This latter expression has been defined in 341 and 342. A bare reading brings out the quintessential concept that they, brackets, there, are no castes in the Hindu fold, but an amalgamation of castes, races, groups, tribes, communities, or parts thereof found on investigation to be the lowliest and in the need of massive state aid and notified as such by the president. To confuse this backwardmost social composition with caste is to commit a constitutional error, misled by a compendious appellation. So that to protect Harijans is not to produce prejudice any caste, but to promote citizen solidarity.
In fact, by using the expression, this mixed bag,
Yes.
the learned judge is really underscoring the heterogeneity of the
Exactly, exactly.
Then in the latter part, he says, but as a large backward group,
That's correct.
deserving of societal compassion.
Correct. Now, this is quoted by Justice Hegde and comes to the conclusion that it forms a class. Now, kindly have a look at that. PDF 796, volume 5.
It's 796.
Yes, volume 5.
Para
23. This is where the judgment 22 also is erroneous.
The way of doing it is that not to deny that they form a class, but they form a class for the purpose of Article 341.
That's right. That's right. Absolutely.
So they may be a class for certain purposes, they may not be a class for all purposes.
That's correct.
Basically what you said in your submission.
There is a level of, what should I say, Mala, discrimination which runs through this entire list. But their vocations may be different, their historical, the way they were treated may be different, there may be so many differences. The numbers may be different. The extent of discrimination also may be different. Level of discrimination may be different. For example, Malas, what we are dealing with are Majbi Sikhs and Dalit Sikhs, Malas. Now, do you know what the origin of this is? The origin of this, what is the origin of Majbi Sikhs? Guru Tegh Bahadur Malas, his body was mutilated. And he brought that body to Guru Gobind Singh. And he was a Chamar. The person who brought that body was a Chamar. So Guru Gobind Singh took him in his fold. And therefore the Chamars became part of the Sikh community. Now what has that got to do with this list? That's the historical context. Yes, begin. Mazhabi means faithful.
There is also an entry with regard to Chamars
Yes,
in Punjab.
that's right. And that's why, Malas, your lordships find that the 32% of the population of Punjab,
Completely.
32% of the population is Dalits. More than any other state in this country. Sweeper. He was a Chuda. He was a sweeper.
Pishti.
Whatever.
He was a Pishti. One who, yes, whatever. He was a
Water.
Pishti.
There are others also. In the list also, there are lots of, anyway.
That happened, my lord, near Chandni Chowk. The incident.
Yes, of course.
Uh,
I'm quite familiar with it.
Which is that? Gurdwara is there.
Now, Malas, just come to this volume, PDF 796 of the same volume, paragraph 23, where he quotes Malas, the learned judge quotes Justice Krishna Iyer. That's the 135 that I read to your lordship.
Para?
135.
No, para 23, where he quotes
Paragraph on
135,
that page,
which I've read to your lordships. And then he says in para 24, the learned judge, according to Justice Krishna Iyer, though there are no castes, races, groups, tribes, communities, or parts thereof in Hinduism, the president on investigation, having found some of the communities within the amalgam as being lowliest and in need of massive state aid, including them in one class called the scheduled caste. The secretary thereof is that the scheduled castes are one class for the purposes of the Constitution. One has nothing. That conclusion is ex facie wrong. So I've demonstrated heterogeneity. I've demonstrated, Mullahs, that the basis of the judgment is that there is homogeneity. That assumption is wrong. And on that ground alone, Malas, the judgments must go.
Yes.
Now, sorry. Yes. So, Malas, therefore, now if you read 341 now with me, Malas, your lordships will realize, Malas, that in fact what Justice Krishna is saying is consistent with 341 itself. Kindly read 341.
Prima facie, that observation that it amounts to tinkering with the president list in the presidential order, that doesn't appear to be, because they
Absolutely.
don't say that if you remove comma or.
Absolutely.
Nor are they saying that this particular caste is
Okay,
a
this
synonym of whatever is a designated caste, that
Exactly.
include therefore this caste. Not is the state of Punjab arguing it, that though
No,
these
no.
castes have been not designated, these particular castes are also are synonyms or belong to the same.
Absolutely.
That you can't do. That even we can't do as no,
Exactly,
it's
exactly.
beyond the power.
Exactly. Now, if you read 341 with me, Malas.
341.
Yes. The president may, with respect to any state or union territory, and where it is a state, after consultation with the governor thereof, by public notification, specify the castes, races, or tribes, or parts of or groups within castes, races, or tribes, which shall, for the purposes of the Constitution, be deemed to be scheduled castes in relation to that state or union territory, as the case may be. Heterogeneity is writ large in 341 itself.
Anything else on the first point?
Well, just one point. Your lordship asked the question why the word deemed is there.
Right.
Well, I just wanted to answer that because
That
it is there because
That the learned AG wanted to know.
because Malaj, it can't be changed till Parliament changes it. It's deemed to be. Nobody can tinker with it. That's the reason why deemed is there. Because 2 says Parliament may by law include or exclude. Till such time as Parliament passes, it's deemed to be. No state government, no central government can tinker with it after the presidential order. So that just to answer that question that arose. Now let's come to the second point that I was arguing.
Yes.
Namely, that this has nothing to do with reservation. Now kindly come, brothers, with the greatest respect, kindly come to the chapter, how it starts. Special provisions relating to certain classes. That's chapter, part 16. Now, your lordships will find in this chapter wherever the Constitution wanted to provide reservations, it said so. I'm not saying that the union government cannot ensure that there are, that's not the point, Mullah. That power the union has, that power Parliament has, that's not an issue.
16.4 doesn't refer to reservation.
16.4 does. I'll show, Manas. That also is a misreading of 16.4. I'll show that presently, Manas. Just allow me to take this.
330 expressly says reservation.
Yes. Reservation of seats for scheduled castes, scheduled tribes in the House of the People. Kindly come to 331, 333, 2, reservation of seats for scheduled in the Legislative Assembly. Then come with us to 334, reservation of seats and special representation to cease after certain period. 335, claims of scheduled castes and scheduled to services and posts. And then, Malas, your lordship comes to the National Commission for Scheduled Castes, which is 338, which Malas does this exercise because that recommendation is sent to Parliament. Parliament then decides whether to exclude or include. That applies thereafter to National Commission for Scheduled Tribes. And then your lordships will see for the backward classes, 338, 38B. And then you come to Scheduled Caste 341. So the scheme of the Constitution is clear. 341 is meant to identify the heterogeneity of those communities and castes and tribes who have been dehumanized over centuries. The power of reservation, your lordships will find in 16.4.
Mr. Sibal, in any state, is there any reservation under Article 330 specifying the communities which have been included in scheduled caste based upon their population ratio or something like that? No.
No, I don't think so.
Like Valmiki is 5 seats
No.
out of total of 100 seats,
No,
supposing
no,
coming
no.
for.
So in Parliament, it's only for either scheduled caste or scheduled tribe.
That's all. That's all.
But then there can also be cluster classification in that also.
No, there's.
There is none. There should not be either, Malas.
Why?
For the simple reason, Malas, the representation of the caste to take forward.
I
the
think as
interests
a
of-
matter of fact,
Yes,
insofar as parliamentary elections are concerned, even a scheduled caste from Punjab can contest in Maharashtra
that's correct.
against the scheduled caste.
That's correct. That's correct. Because when we're talking of reservations, we are talking about education and employment, not representation. No, Quake classes, Quake different. Your lordship is right, but the problem there is, they can contest, each one of them.
Reservation for appointment is.
No, they can contest, Malaj. They're not prohibited from contesting. So that's what the privilege is only to contest. That's the reason why.
A higher population will always succeed.
That's true. That may be true.
Of a community which has very little.
Hopefully, Malaj, that situation will not rise.
So therefore, there was a debate
Yes,
in the Constitution because Dr. Ambedkar, so prior to Pune Pact,
absolutely.
he wanted resort seats specifically.
That's right.
Then ultimately Gandhiji went on a hunger strike and
Reserved.
Therefore, it was reversed. It was reversed.
And electorate.
Yes, it was reversed. So if you look at 16, Malaj, something very interesting emerges. First of all, Malaj, let me tell your lordship the difference between 15.4 and 16. Kindly read 15.4 with me. You will find no mention
Reservations.
of reservation.
It's special measures.
Special measures for advancement. This is important.
That's right.
Nothing in article, Malaj, let me read the whole. The state shall not discriminate against any citizen on grounds of religion, caste, sex, etc. No citizen shall on grounds of religion, caste, race, caste, sex, place of birth, or any, have, with regard to access to shops, public restaurants, hotels, places of public entertainment, or the use of wells, tanks, bathing ghats, roads, places of. Now, Malaj, these special provisions under 341 can relate to this.
that's what the learned AJ argued. that the, and Mr. Farasat also, that Chennai, they failed to consider interplay between 341 and 16.4.
But I'm not on 16.4. In fact, I'm going to make a distinction between 15.4 and 16.
That 15.4 may also comprehend reservations as well.
It does, Malays, it
But
does.
the
It does.
concept of special provisions for advancement
Would
is
include.
broader than just reservation.
I agree, but I'm just only saying
Reservation
advancement.
postulates a quota, while a special provision, maybe
Yes.
quota plus. It
Exactly.
could be relaxation,
Exactly. In other
scholarships,
words,
anything.
The reason why I'm saying this, the reason why I'm.
15.4 was brought because it was held by this court that there can't be a reservation.
That's right.
In 51.
That's
They struck down community-based reservation.
You are-
Champakam Dorai Rajan.
Apakam Dorai Rajan.
Miller, there's a reason why I'm making this submission, Miller, for your lordships to consider, Miller. And that is, there is a symbiotic relationship between 15 and 16.
Symbiotic relation.
You reach 16 only when you are empowered under 15. If you're not educated, you can't get employment. It's simple as that.
For a member of parliament, there is no
I'm
qualification.
I'm talking about in the larger context, Malas. We're talking about 21st century, Malas. We're talking about the 21st century, Malas. Of course, some of them can,
The same
some
school,
of us-
14, 15, 16.
some of us can hold the highest positions in the country without being, so that's another matter, Malas. Some of us, Malas, have reached corporations, Malas, and manage corporations without necessarily being fully educated. That's not the point. The point is, Malas, there is when you're talking about this section of society, there's a symbiotic relationship.
So we must recognize that the Constitution is not prescribing qualifications such as property, education, gender. This was an article of faith.
Yes.
And it was a very visionary provision because ours was one of the first constitutions which did not make your right to contest an election or to hold electoral
Yeah, I
office
agree.
conditional on
I agree entirely. And it's a
conditional on
statutory
gender or property or
We should-
your educational qualification.
I'm with you on that, Malas. I'm arguing something different. What I'm saying is if this class of people that you call a class, if you don't empower them under 15, you're not going to get representation under 16.
So in that sense, 15, as you said, they share a symbiotic relationship because unless you create the foundation for employment,
Right.
you'll not get employment.
That's-
You need a qualified workforce to be
It's only in that
in the
limited,
workforce in the first place.
it's in that limited sense that I'm talking about this. That's all, nothing more than that. Nothing more than that. Now, if you look at 16.4 now, in this context, it doesn't also talk about Malas, scheduled castes, scheduled tribes. But if you go to 16.4A, it talks of scheduled castes, scheduled tribes.
The judgment of this court.
That's right. So if you are not included in 16.4, how do you get Malas, reservation and promotions? 16.4 has to include scheduled caste, scheduled tribes because they are backward. They come within the genus of backwardness. So 16.4 is an answer, 4A is an answer that 16.4 includes. Yes. In the volume 4A, Malas, that I have uploaded, 4C. 4C, no, 4C. Yes, just see, Malas, I've given to your lordships in volume 4C, page 13. PDF 13. There are various acts that have been passed which is why 341 and 15.4 allows for advancement through various legislative or executive measures.
Reservation could be one of them.
Yes, reservation is one of them. And it's integral. I'm not
The
saying
universe is much wider.
much wider. So therefore, I've given some of the, I've given us, you have the Karnataka Scheduled Caste, Scheduled Tribe Prohibition of Transfer of Certain Lands Amendment Act. You have Scheduled Caste, Scheduled Tribe Prevention of Atrocities Act. There are all kinds of, you have the Protection of Civil Rights Act of 1955, all kinds. So Mullahs, therefore, I just wanted to, and Mullahs, when we look at reservations, this will never end. This is an unending exercise that we are going through as a nation. The reason is very simple, Mullahs, that unless 15.4, unless you advance under 15.4, you'll not go to 16.4. So if you look at Mullahs Punjab, and we don't get, I'm not going to the numericals of it, but the fact of the matter is that the total population is of these is about 280,000. Government post is 280,000, approximately. I'm just giving you lordships.
Of Mazhabi Sikhs.
No, total government posts. The Mazhabi Sikhs and Dalits are about 32 lakhs. Total number of posts are 280,000. Out of that, Mullahs, 25,000 goes to scheduled. 25% goes to these classes, backward classes. Of the 25%, 50% comes to Mazhabi and Dalits.
Mazhabi and Valmiki.
And Valmikis. 50% come to Valmikis. And I am told, Mullahs, how many seats have been actually? Total. Most of them are not occupied even.
And it's preferential, so it goes to anybody else.
Yes,
then.
and
You
it will
don't
go
carry
to
forward.
anybody else. Most of them are not even occupied. What does that tell you? What does that tell you? And that's very important. I want your lordships to actually mention it.
That posts are not unoccupied.
Well, they will give you the data. Actually, I've asked the state.
Yeah, maybe there is no adequate representation insofar as Mazhabi Sikhs and Valmikis are concerned.
No, the others also. In fact, I've got some data, but I've asked the state, they'll give you the data. I've asked by this evening, we'll get that data.
Therefore, your point that unless there is educational advancement under 15 and social advancement.
That's right.
16 remains teasing.
Dead letter. There'll be cases after cases on the same issue for times to come. And if you can have Kasturba Gandhi schools for girls, why can't you have schools for Mazhabi Sikhs or these communities? Not just for everybody. That's the way forward for the nation. You don't empower them, and then you keep on fighting that there are not enough people in promotion.
All right, yes, Mr.
Well, therefore, I beseech your lordships, but this is an area your lordships should say something.
All right, anything further, Mr. Sibal, now?
Yes. Now, well, just my written submissions, then I've done. Because I don't want to take volume 1B, PDF page 29. Where is 1B? Yeah. So, well, I'm not going to take your lordship because there's no time. Just come to the page 54. Para 54, Mullahs. PDF 27. Just a quick look at that, Mullahs. The table, I'm going to show that table. Yes, your lordships will see that para 54, it's
PDF?
PDF
Page 27.
27. Running page 26. Mullahs, it says A, Mullahs, small paragraph A, a study of Punjab caste done in 1883 found Mazhabis belonged to the Chura caste and were primarily scavengers and sweepers. as per the report of the Evaluation Committee on Welfare regarding welfare of SC so and so, for a period commencing 15th August 47, dated 65 to 66, Mazhabis had a total population of 664,000, while Balmikis had a total population of so and so. Said report also found the social conditions of Scalinal were awfully deplorable. They didn't even have proper access to utensils, let alone housing. They had meager income, were forced to do scavenging despite working from dawn to dusk. The report also noted that educationally they were extremely backward, even more. The literacy rate is around 41%. So Malad, all I request your lordships is read through this, please, because I don't want to waste your time. This will tell you the situation that we are in. And I'm deeply obliged. I didn't want to repeat anything.
Thank you, Mr. Zulu. Thank you.
What?
Mr. Solicitor?
I'll take only 10.
We'll hear the solicitor so that.
No, Mr. Venugopal was on screen.
So Mr. Venugopal should argue
No,
first.
I'm sorry. He's
Well,
on
that's-
screen, he was supposed to go next, but he has said, there's been a bereavement in my family. So he has said that I could go before him. Both him and Mr. Nidesh Gupta have been kind enough to say that. I just wanted to inform you.
Certainly, you have to leave the
Because you
court.
have an order, that's why I want.
Certainly.
Malad, just one issue, Malad. Indira Sani, paragraph, note it, Malad, please. PDF 689, paragraph 778.
Just one second.
Yes.
Sani, volume?
Volume 5, PGFK 689, paragraph 778, they explain as to why in 16.4 the word class is used and not caste. They explain. I just read it. Indeed, there is a very good reason why the Constitution could not have used the expression caste or caste in 16.4, and why the word class was a natural choice in the context. The Constitution was meant for the entire country and for all time to come. Non-Hindu religions like Islam, Christianity, and Sikh did not recognize caste as such, though, as pointed out herein above, caste did exist even among those religions on various degrees. Further, a constitution is supposed to be a permanent document expected to last several centuries. It must surely have been envisaged that in future many classes may spring up answering the test of backwardness, requiring the protection of 16.4. It therefore follows that from the use of the word class in 16.4, it cannot be concluded anything else? So therefore, the judges say the word class in 64, in our opinion, is used in the sense of social class and not in the sense as
We'll have a look at
it's
it.
antithetical.
Thank you,
I'm
Mr.
deeply.
Mr.
It's
Shankar
okay
Narayan?
now, we can't, there's, others have to also argue.
Sitter wanted to address your lordship, I think. he has
Mr. Attorney, Mr. Shankarayan, there's been a bereavement in his family, so he has to leave. So can we hear him for 10 minutes or so, and then we will,
You didn't request me for that. Of course he can.
Well, may I be
Of
excused?
course he can.
Want to go? Ajus volume what? Wait, please, ma'am. May I just start with expressing my gratitude to all the seniors who should have gone before me, who have been kind enough to let me go before them. I'll just keep it very brief. There are just 4 points that I want to make. If your lordship would be kind enough to have volume 4B, B for Bombay.
What is the first point that you would make? So then we'll take it.
I'll address the 4 points. The 4 points are these. First, that in identifying the scheduled castes and scheduled tribes, a bit of a historical context is necessary, because eventually we're talking about how you will classify within these groups for the purpose of giving them measures. So the historical context will broadly show you how they first come to be identified. Why are they forever called scheduled castes? Where does that schedule come from? It comes from the Government of India Act 1935, and there's a background behind it. It starts with the census in 1891. I'll briefly touch upon that. All of that is in volume 4B. The second, this will also briefly touch upon that question that fell from the bench yesterday about why tribes, the word is used while defining scheduled castes.
In 341 also.
Yes. Why is it used there as well as in 366? In both places, scheduled castes are including tribes. Why does that happen? The second, Maloj, is that the constitution and its approach towards scheduled castes and scheduled tribes. You'll find that it was a very, very important and integral part of our constitution making, starting from the Pune Pact, starting from many other big leaders, both from the Dalit community and outside, who were responsible for ensuring that many provisions of the constitution were infused with this, taking steps. Article 15, which has provisions which come from the Pune Pact, Article 17 and its abolition, exploitation provisions in 23. All of these, along with 15, 16, yes, of course, that's what we keep dealing with. But we must draw a small distinction between 15 and 16, which are provisions which are not automatic, which don't immediately give a right to a member of the backward community. It is for the state to make a law under 15, 16 if it so wishes. So 15, 16 are enabling provisions. 330, 332 and the provisions dealing with municipalities and panchayats give them a right. So how that started and that context under the constitution will perhaps help, I think, this bench in looking at the context in which we are arguing this case. Because in my view, at least my submission is that this subclassification is to be done at the end when the enabling provision is being activated. It is at that end that you decide while dealing only with 15, 16. That subclassification cannot be, and I think it came in the discussions earlier today, in 330, 332, etc. That can't be done. It's on 15 and 16.
Or the Panchayat Raj and
Yes,
municipalities.
or panchayats or municipalities. That's the second limb of the submission.
Yes.
The third, it's been touched upon by Mr. Sibal. I won't spend too much time on it. That error in Chinnaya, while looking at the Thomas paragraph of Justice Krishna, in fact, I'll make this point right away. It's just that this is an editorial intervention, an unnecessary editorial intervention in the SEC volume, which has caused this confusion. What exactly happened is in N.M. Thomas, Justice Krishnaiyer uses the word they, T-H-E-Y. He uses that to refer to the various groups, etc., who are the Dalit community. He says that they aren't part of the Hindu groups. Unfortunately, when the editor published in SEC this judgment, within brackets, it put SIC, SIC, there, T-H-E-I-R. Now that there is treated by Justice Hegde in Chinnaya to mean, therefore, a complete homogeneous group. They and there made a big difference. I'm just making this submission. The Lordship may see those two paragraphs, but I don't want to spend too much time on that.
Right.
And finally, there are a few questions that fell from your Lordships yesterday. I just want to address each of them. I think there were some doubts that your Lordships had. So I'll just do that briefly. If your Lordships, the first main limb is going to be the first two, 4B, volume 4B, B for Bombay, of the compilation. And I'll quickly go through that.
Editorial mistakes can sometimes cause very grave blunders.
Correct.
In fact, when we wrote I wrote the 7-judge judgment on the Arbitration Act.
Yes.
It was an editorial blunder in one of the private publications which was handed over to the bench.
Oh,
which
Interesting.
pointed out that a particular provision was brought into force when it was exactly to the contrary.
oh, it wasn't brought in. Okay. Well, that's very risky, Manoj. 7 judges, we should
And
be
it
careful.
was, and so we noticed that and corrected the error in 7 judges.
Well, so if I can trouble your lordships with volume 4B. 4B for bomb. I'm sorry, yes.
What is the fourth? Volume 4B?
4B, B for Bombay.
This is your fourth point.
No, this is a volume for my first point. I'm just taking your lordships to the
Volume.
compilation.
Answering the queries raised.
Compilation, volume 4B.
Volume 4B.
Yes. Yes. Not right now. 4B, my lords, if your lordships will take the first page, that's the census report of 1891. Your lordships have that? Census, that's page 2 PDF as well as running page.
No.
Same.
No.
That is Dr. Ambedkar Foundation, that is writings and speeches.
Volume 4B for Bombay? 4B?
4B.
Dr. Asa Ambedkar writing and speeches, chronology of events.
Ask the nodal council.
No, I've been told.
No.
No, we have downloaded it as Roman. It's Roman 4B.
Roman 4B.
It's for others also. It's census report. I'm sure. Sorry if there's.
Roman
disconnect.
4B.
Huh? The one your lordships are referring to is 4A.
4B.
Oh, 4B. Oh, I'm sorry. Then would your lordship check 4A? Because we have all been told that it's 4.
Also has some reference to Norway incident which Mr. Faraz yesterday mentioned.
Okay. So I'm sorry.
4A has Constituent Assembly debates, etc., etc. The Tyranny of Merit, Michael Sandel,
Let me check which volume this is.
Meritocracy Trap,
Huh? Could you
item 8 and
Just
look
take
at
a
it.
4C, 4D? Sorry. 4B. Oh, this is. Yes. What do you say? No, let it be. I'll just address them.
We can give a.
Look, it's filed a volume. The third compilation. It's not there. But. No, we checked with the nodal council. He said it's been uploaded. If it's not, I'll just anyway address your lordships then. It's going? We'll go right now? Okay. But they'll just uploading it. I'll just address your lordship. I don't want to take time. I'll just briefly tell your lordship what it is. There is an 1891 census report. It was the first census report. Now that census report went into a detailed enumeration. At that point of time, what they did is they went through occupations because throughout the 19th century, the British had come up with many reformist processes from their end as far as the Hindu community largely was concerned. Your lordships know everything with reference to Bentinck's reforms, etc. But towards this end, they wanted to find out what the various occupations were because they found that within the large Indian communities, you would not have intermarriage, you would have people living on the edges, not allowed to share water, not allowed to eat, etc. together. And they looked at the various occupations because many groups were being excluded completely from the occupations. So occupation-based census is this one of 1891. And this provides for the manner of the enumeration, the classification of the occupation, and they specifically say that with reference to these, what they came to refer to as depressed classes, that's the phrase that they used to use then until it was dropped in 1935. The depressed classes, they said that there were many, even within the Rajputs and the Jats, they didn't look at them as castes, they looked at them as tribes. That is where, my lords, this notion of tribes for the purposes of the depressed classes. We are not right now talking about the scheduled tribes, scheduled castes. With reference to them, they refer to them as tribes. And they mention community-wise the various groups which are dealt with, which includes 10 minutes. the various tribes. And they divide them into various classes. Class Roman 7. Class 7 are known as the menials. Those are the ones today who have been come to be described as the scheduled caste. This is stage 1, 1891. The next one is 1930, which is the Indian Statutory Commission, which goes in detail into these depressed classes. The phrase depressed classes eventually came from a report of 1918, which became a part of the Montague-Chelmsford reforms. But they refer to, they use the phrase, employing the phrase depressed classes. They look at these statistics from previously and say nearly 20% of the population belong to these classes. They say that these classes are partly functional and partly tribal, and they mention the various types of disabilities that these groups have been suffering over a period of time. The 1931 census is the third in this sequence. And it was carried out by a famous anthropologist at that time, Mr. Hutton. And he says, for the first time, he refers to primitive tribes. This is where the concept of scheduled tribes come in. They say that there are many tribes because the exploration of India for the British census takers was taking time. So they reached Nagaland, Arunachal, etc., and discovered many tribes which are nomadic or in jungles and forests, etc. And they refer to them as primitive tribes who haven't really come in contact too much with society. And they refer to them. 1931 is the first time that you find that there are these primitive tribes as well. This is for the purpose of the identification. And they shift in 1931 from depressed to referring to them as the ones formerly known as untouchables, and say that we shall refer to them as the scheduled caste. Now, the reason why scheduled caste is that in Government of India Act 1935, they eventually laid down that for representation in the federal legislature, there would be a first schedule to the Government of India Act, which would provide how the various communities were going to be represented. Now that, I think they're just transferring it. That is the one thing I'd like your lordships to see, because all these communities that you find, where did in 1950 did the president suddenly get this list? He got this list from the first schedule of the Government of India Act 1935.
Right.
And we continue to refer to it as scheduled caste and scheduled tribe because of the schedule in the 1935 Act, nothing to do with the Constitution itself.
Right.
It's come. Can your lordships now see it, Manoj? It's on screen.
Yes.
Yeah, I can see that. It's good. Just if I can trouble your lordship, I've told your lordships the first, that's the 1891 census report. Then the next is that statutory commission report. There are page numbers. I'll give that to you in a single note, my lords, because I want to keep it short. And then is the 1931 census. And then the Government of India Act 1935. If your lordships would be kind enough to come to page 58. That's where the
I
act
didn't do
starts.
this, Mr. Shankaran.
Yes.
Today you have cleared the court, but you can add to your submissions
Yes.
just an addendum
Yes,
and make sure it goes into our copy.
I'll do that.
So that, then you can also, we'll label this particular compilation as volume whatever.
Yes,
You can give us a 2-page note
I'll
on
do-
the evolution.
I'll do that.
And I think that
This is why I'm trying to keep it short. I'll just highlight what I'm saying. Just for a minute, if I can trouble your lordships only with, of this volume, page 185. This is the first schedule. The lordships can see that. It's marked. It's the first schedule to the Government of India Act. And in this, my lords, entries 4, 8, 18, and 20. Your lordship may note that. Entry 4, for example, I'll just read to your lordships. To each governor's province, chief commissioner's province, and community specified in the first column of division 1 of the table, there shall be allotted the number of seats specified in the second column opposite to that province or community, and of the seats so allotted to a governor's province or a chief commissioner's province, the number.
Was the expression scheduled caste defined in the, and
It is defined. It is defined in 26. Yeah, but I'll just, 4, 8, 18, 20 refers to scheduled caste.
Yeah.
And 26 defines scheduled castes. So just, it's the exact same definition that you find now in the Constitution of India. 26. Can they go down? Can you scroll down? 26. That's at, I'm sorry, that's at page 189, PDF 189, the middle of 189. Yes, the scheduled caste means such castes, races or tribes or parts of or groups within castes, races or tribes, being castes, races, tribes, parts or groups which appear to His Majesty in council to correspond to the classes of persons formerly known as the depressed classes, as His Majesty in council may specify.
Same schedule.
So this is copy pasted effectively and put in the constitution. Immediately after this is the scheduled caste order of 1936 by the King and Council, Manoj, which is at page 253. It's very interesting. The previous year, 1935, Government of India Act is by George V. This is by Edward, who abdicated, as your lordships remember, because of that. So in the 1 year that he was king, page 253, this is issued, first paragraph, page 253. Whereas by certain provisions in the first, fifth, and sixth schedules to the Government of India Act, His Majesty in Council is empowered to specify the caste, race, or tribes or parts of the groups within caste, race, or tribe, which are to be treated as the scheduled castes for the purpose of those schedules. And it's not only schedule 1, but other schedules as well, as you'll find from para 2 of this in the middle of the page. Subject to the provisions of the order for the purpose of so-and-so schedules, these are the ones who will be specified. Para 3 is interesting. It says, notwithstanding anything in the last preceding paragraph, no Indian Christian shall be deemed to be a member of the scheduled caste. No, in Bengal, no person who professes Buddhism or a tribal religion shall be deemed to be a member of the scheduled caste. This is after the partition of Bengal.
Yes.
And next page onwards are the castes. So these are the castes, tribes, all of them, state-wise, as per those states, Madras, etc. Now, this in its entirety, this goes on for several pages more. This in its entirety, community-wise, was what was replicated in the presidential order of 1950. The presidential order had to be amended a few times every time we had a reorganization of states, because it was unclear whether that community will remain an SC for that partitioned state or not. So they did, every time there was a reorganization in 56, 59, they did actually amend the presidential order of 1950. I'm quickly coming to my second limb. This is to give your lordships context and to say that these are the groups. Therefore, at a later stage, when you come to enabling provisions, when you decide to give those communities, if some of those communities have been, say, for 16, adequately represented, then it is incumbent on the state not to repetitively give them who are adequately represented that benefit. I think that point has already been made repeatedly. Second, I'm just handing this over. It's there in this volume as well. It's there in volume, yeah? Just take 7 copies. This, Maloj, is something I had submitted in the EWS reservation case, the 5 judges, just which has been included in the Janhit Abhiyan judgment, in fact. It's a chart showing reservation provisions under the Constitution. All the provisions are here, which are dealing with this, just to help address your lordships on. It's in this also. It's at page 805 of this volume. It's at page 805, but I'm just addressing it from here, if I may. This is to show the provisions, Malons, which govern each of these communities. The central one, the red one, is SC/STs. The one outside that is SCBC, OBCs. And the one at the outermost is EWS. We can ignore EWS for the time being. SC/ST, the definition provisions are there. Then the special provisions are there. Now, why we have color-coded it separately is for the parameter that has to be applied. The parameter that has to be applied for the scheduled castes and scheduled tribes with reference to 15 and 16 is historic untouchability. Because I think there has been a general sense that social and educational backwardness is the determinant for being an SC/ST. That's not true. For being an SC/ST, it is about its historical backwardness and it's a constitutional atonement for those years of discrimination. So for determining who the scheduled castes are, and this is what even the 5 judges decision in Mari Chandrasekhar says. Specific paragraph I'll give you, it's para 9 of Mari. Mari is, I'm sorry, it's not part of this volume, but it's the paragraph is extracted. It says that it's the historic untouchability which is for the determination of SCs. Social and educational backwardness, which is defined in the Constitution in Article 366, says for the purposes of this Constitution, socially and educationally backward are those who are determined by way of the list which the President provides. But that came in by way of an amendment, that definition, because after the Indira Sawhney judgment, the Indira Sawhney judgment gave one direction to the government. It said that please ensure that you set up a national commission for the backward classes, and they set up a national commission. There was a National Commission of Backward Classes Act. Subsequently, when the Constitution came to be amended, that national commission was taken and put on a constitutional plane, from statutory to constitutional. And therefore, the definition had to be given of who are socially and educationally backward classes. Now, there has been a little bit of debate in the past whether socially and educationally backward classes is the phrase used in 15. It's not used in 16. In 16, you say backward classes, which is why you get the O in the OBC. You have SCs, STs taken anyway to be backward classes for purpose of 16. Other backward classes are those outside of that. Are they the same as the SCBCs? The Constitution seems to suggest to us, courtesy all these amendments that have come, that they're perhaps the same. We don't have a fourth list of OBCs. We just have the SCBC list. That's the one that's adopted. But for determining the scheduled castes and scheduled tribes, it's historic discrimination. So that pink one shows that that's historic untouchability. Now, the reason why I put the blue ones, your lordships will see,
The political backward.
political backward.
Political reservation.
So in municipalities and panchayats where you have these provisions, as well as in the Lok Sabha and the legislature, these are the political backwardness determinations that have to be made. The third, of course, are the social and educational backwardness, which are in yellow. Now, one small distinction, I think, which is essential for answering the question that has been referred to your lordships is simply this, that the idea in the Constitution at the time the Constitution came in, the SC/ST communities had only one provision of reservation to them, which are the ones in 330 and 332, nothing else. As a provision of reservation available to that community, it was only in the legislatures and parliament. Subsequently, when enabling provisions were activated from the outset, from Champakam and Venkatraman, both decided in 1950, or one on 15 and the other on 16, there was an activation of that. Even though the GO was prior to the Constitution, there was an activation of 15 and 16. Once you activate 15 and 16, does the state not have the right to say that, look, your list which the president has made, that remains intact. I'm not trifling with it. But for my purposes, where 15 and 16 gives me the right to make a measure, I believe that these communities need to be favored. Now, whether the choice of those communities by me is right or wrong will be determined based on reports, based on other data. The Indira Sawhney judgment says use the barium chemicals measures to determine that. But that list remains intact for the purposes of the political representation. So for municipalities, panchayats, legislature, and Lok Sabha, I can't touch it. The state has absolutely no role to play in that. That remains. I hope I'm making myself clear. So that distinction is necessary. This entire debate here is really only about 15 and 16. Because the definitions, both in 340, 342, as well as in 341, 42, as well as in 366, make it clear for the purposes of this Constitution. So the SC/ST determination or definition for the purposes of this Constitution encompasses the mandatory political representation for which the state has no role to play at all. It can't interfere in any way. And where the state has a role to play. It's only in that where the state has a role to play under 15 and 16 that it is the entitlement. In fact, it's a constitutional obligation of the state to make such determinations. So this chart is for that purpose.
We've got the point. Should be now closed.
The last thing is to address those questions. One more. There's a judgment of your lordships, which is in this compilation at page 353, my lords. This is a small concept which may be relevant. This is a judgment of my lord, the Chief Justice and Justice Shah in 2021. This is at page 353.
Yes.
Patan Jamal Wali. It was dealing with the outrage, the rape of an SC/ST lady who was also blind. Now, two paragraphs just see para 17 at page 372, internal 372, para 17.
Yes.
This principle of intersectionality, I comment to this bench. Intersectionality can be defined as a form of oppression that arises out of a combination of various oppressions, which together produce something unique and distinct from any one form of discrimination standing alone. While the model of intersectionality was initially developed to highlight the experiences of African American women, there is a growing recognition that an intersectional lens is useful for addressing the specific set of lived experience of those individuals who have faced violence and discrimination on multiple grounds. A single axis approach to violence and discrimination renders invisible such minority experiences within a broader group, since it formulates identity as totemic and homogeneous, which is precisely what Chinaya has done. Each of these communities have lived experiences which are distinct from each other. Even in Indra Sawhney, I'll give you a lot of the paragraph, there is a acceptance. Justice Krishna and Anam Thomas says that even within the scheduled castes, they're not all alike. They're all very, very different. They have different experiences. But I won't read the rest of the paragraph, but I believe this paragraph
Yes.
and
Para.
para 795 of Indra Sawhney. Both of these, your lordships may just consider. Now, quickly, I'll just address the questions that came yesterday. Justice Nath had asked a question that once people have achieved to a certain extent, wouldn't you remove them from the list? That's not a call for the state to take for two reasons. One, that they don't have the power, that's for the president to do on recommendations by the state. But when you remove, when they've reached that level, you have to see that they've reached that level not only in my domain of 1516, which is education and employment, and everything else
Why
socially.
can't the state take that call? State
No,
can always
because
do it.
the removal
Once
from
the
the
state is
list.
deciding to
Yes.
allocate extra percentage of reservation for specific communities
Yes.
within that scheduled caste group.
Yes.
It can say that these are already adequately represented, they don't require any reservation.
Yes.
Why not?
No. So the
That the
problem is
state has
this.
to implement
The
41.
under 15 and 16,
Yes.
it becomes implicit because the state, when it's giving its reservation, says, I choose these 10 communities and I give it to them. So the
64
others get excluded.
64 is backward class.
Yes.
You can always say this backward class does not require any further.
I
reservation
don't think
because
the
it is
negative
adequately
declaration
represented.
is necessary when they
State
positively.
exercise, not the
So
parliament exercise.
So if they give the entire extent of their reservation,
They can
so
continue
state
the
10
scheduled caste
communities.
to gain
Yes.
advantage of 15(4) or
Yes.
any other provision.
No,
Or
so-
330 or whatever.
Yes.
But for
So-
16(4) is concerned.
Yes.
They can always exclude.
Yes, so that comes to the second question, my lord. The Chief Justice posed to the Advocate General yesterday. If there are only two communities and you decide, can you give entire 100% of the reservation to them? My answer is different. My answer is yes, you can. Because the idea of this constitution is that at some point you will, because you'll reduce from your 100 caste groups. Hopefully, we are moving forward as a nation. If you keep moving forward as a nation, some of these communities will get adequately represented, will move forward. So from 100, you'll come to 50, 40, 30, at some point you'll come to 2. And you'll say, look, these two are so terribly ravaged that there is no question that I'm going to give my 100% of that reservation available to me to them. Both the quantum, that is percentage, as well as the number of communities is in the state's hand. So the state doesn't have to give 40%, state can give 4% reservation and say the entire 4% will go to 2 communities. So that's to answer the second question, my lords, which I believe that would be the correct answer, the consistent answer, because this constitution and its interpretation not for today. When we have 7 judges going into this, 20 years from now, we may hopefully reach a stage where we will have only 2 communities and we'll be able to take care of them also. And this, yesterday, Justice Gawai had a question about the creamy layer application in the SCSTs. Now, Nagraj said so, saying that 16.4a, 16.4b as a constitutional challenge can be sustained only if it has these controls: efficiency under 335, administration, the adequacy, and creamy layer. In Jarnail, when that question had to be referred to a larger bench, they said, we're not referring to a larger bench, but this backwardness determination for SCSTs is not necessary. It's implicit. Removed that. Kept the other 3 intact, reiterating the fact that creamy layer applies to SCSTs. So creamy layer applies to SCSTs because it's an individual removal. But in practice, on the ground, there has been no office memorandum that I know of, the state may assist, which they have issued for the creamy layer removal among SC/STs. They have one old 1992 office memorandum which removes the creamy layer for the backward classes, which is detailed, which has, politicians, members of parliament, etc. Then income criteria also. But
Shankar, we'll close it here.
I'm grateful, madam. I'm very grateful.
Should we hear Mr. Venugopal first? That was what,
Yes.
Mr. Venugopal,
They've taken.
are you online?
Yes, I'm on the line.
Yes, Mr. Venugopal.
Great, please, Lordships. Lords, much has been covered. And my,
Manoj, may I take your leave? I'm sorry.
Yes, sir. Please.
I'm appearing, Lords, for the Madiga Reservation Porata Samiti. And it's item number 701.22. And it's writ petition 562 of 2022.
You are for the intervener,
No, my lords, I am for the petitioner.
for the petitioner.
Yes, I think,
But only,
Ms.
Mr.
Reddy is,
was the,
Ms. Reddy is for the intervener.
rest are the petitioners.
Now, my lord, so far as this is concerned, I had appeared before the 5 judges in the Andhra Pradesh High Court in Chennai. They had upheld the subcategorization of 61 scheduled castes into 4 divisions based upon their advancement over the years. And they had given, my lords, 7% to the weakest among the weak, 6%, my lords, of the jobs and educational institutions, seats, to, my lords, another group, and to the best, to the highest among them, 1%, 1%. This was upheld on the basis of categorization was permissible. Chennai, my lords, reversed it and said that the whole of them being a homogeneous group, this cannot be done. Now, the basis of, my lords, the subcategorization was an elaborate 200-page, my lords, investigative, my lords, report of Justice Ramachandra Raju. And the judge, my lords, after enamored this, found that there is vast disparities between the different groups in the 61, my lords, subcastes, some of them being, my lords, workers in leather, the scavenging, and, my lords, nomadic and so on, who had been excluded to a very great extent, so that the fruits, my lords, of reservation had been taken over by the more advanced ones among, my lords, the entire group of 61. And that is the basis on which, based on this comparative advancement, my lord, of the groups, he had grouped it into 61 into 4 groups and had given varied, my lord, representation. Now, this is, my lord, what was held by Chennai and, my lords, was reversed by the Supreme Court of India. Now, my submission to your lordships is this. Article 14 of the Constitution, my lord, is a golden thread which runs right through the entire provisions of the Constitution. At the very inception of the Constitution, the founding fathers had examined the disabilities of various groups and had provided in the original Constitution itself for affirmative action for the purpose of their upliftment. And therefore, my lord, if your lordships would be pleased to take my written submissions, which is a short 10 pages.
1G.
It is
Where would we find them? Where will we find them, Mr. Venugopal?
volume 1, capital G, my lord.
Yes. Just a
Your
second.
lordships inclined.
Give us just a moment so that all of us can access it. Yes, it's page 1.
Your lordships will find, if your lordships would be pleased to go to page 5. The various steps taken, my lords, by the founding fathers themselves to ensure that unequals are treated equally with the rest of their category to which they belong. And at the bottom in paragraph, my lords, 11 of page 5, your lordships will find article 15.3, special provision for women and children. Your lordship have got it, my lords. Para 11. I hope your lordships have it. Para 11, my lords, at page 5.
Yes, Mr. Chairman.
And then para 12, 15.4, that is the backward classes. Then it goes on like that. 15.5, scheduled caste, scheduled tribes, admission to private institutions. Then economically weaker sections, 15.6, which your lordships upheld, 10%, my lord, in addition to the 50%, and 15.6b, 16.4, 16.4a, 16.4b, 16.6, 17, untouchability, and 18, which is, my lords, against against titles to citizens, which your lordship has held in one of the judgments, Indian young lawyers, that some people are being placed above the others, and this cannot be permissible, and that is why. Therefore, so far as, my lords, the benefits are concerned, it is in regard to the state has given benefits socially, educationally, in employment, and politically as well. And your lordships will find that politically, it is in article, my lord, when the panchayats were introduced, in para 22, that is seats for scheduled castes, scheduled tribes in panchayats. Similarly, my lords, in regard to, my lords, the municipalities, then the benefit, my lords, to women, where they are given 1/3 of the total seats, rotation of the chairman, where the women will be given, that also. Now, this is, my lords, the broad basis on which the Constitution had approached, my lords, these inequalities which have been prevailing in the population, my lords, of this country. Thereafter, my lords, they found during the course of the working of the Constitution that there were certain, my lords, classes which stood again deprived of what would be, my lords, an equal treatment under the Constitution. And therefore, my lord, amendments were made. And that is how, my lords, so far as the benefits to scheduled caste, scheduled tribes, to entry to, my lords, the educational institutions, including, my lord, private institutions, was provided for. Economically weaker sections were given 10%, irrespective of religion, caste, creed, etc. Now, similarly, very many other amendments. Now, in this background, I would request your lordships to go to Article 28.2 of the Constitution.
38.2, right? 38.2.
38.2. And this, I say, is a fulcrum on which the entirety of, my lord, the problem is to be approached. 38.2 is, my lord, so far as this is concerned, in the directive principles. The state shall in particular strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities, not only amongst individuals, but also amongst groups of people residing in different areas or engaged in different vocations. Now, so far as this is concerned, it was brought in by an amendment of 1978. Now, this would say that so far as inequalities are concerned, they have to be minimized, not only, my lords, that in regard to status, facilities, and opportunities, not only among groups, but also among individuals. And if your lordships would turn to Article 37 application of the principles contained in this part, the provisions contained in this part shall not be enforceable by any court, but the principles therein as laid down are nevertheless fundamental to the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Therefore, my lords, 38(2) is fundamental to the governance of the country, and it shall be the duty of the state to apply these principles in making laws. And this is exactly what the state of Andhra Pradesh has done. And therefore, my lords, the question is whether 341 should not be read along with Article, my lords, 382. There are a number of judgments, my lords, which say that so far as directive principles are concerned, they should be read along with, my lords, the fundamental rights, along with the other provisions of the Constitution.
Right from Keshavanand Bharti.
Yes, right from Keshavanand Bharti. And my lord, Unnikrishnan versus, my lords, Unnikrishnan versus State of Andhra Pradesh, that is Jeevan Reddy's judgment, 1993, Volume 1, Supreme Court Cases, 648.
645.
645. Unnikrishnan versus State of Andhra Pradesh. And this, exactly. From Keshavananda Bharati, Justice Chandrachud, at para 161, is extracted. As I look at the provisions of part 3 and 4, I feel no doubt that the basic object of conferring freedoms on individuals in the ultimate achievement of the ideal set out in part 4. May I say that the directive principles of state policy should not be permitted to become a mere rope of sand. If the state fails to create conditions in which the fundamental freedoms could be enjoyed by all, the freedom of the few will be at the mercy of the many, and then all freedoms will vanish. My lord, similarly, there are a number of judgments which, my lord, would require the harmonizing between directive principles, my lord, and the provisions of the Constitution. Therefore, my lord, the golden thread which runs is not only, my lord, that Article 14, that all persons should be treated equally, but not in that unequals have to be treated also equally, and they'll have to be equalized. And if your lordships will take my written submissions, there is an extract, my lords, which brings this out very vividly. And that, my lord, is Mari Chandrasekhar Rao, referred to in other contexts. But if your lordships will be pleased to turn to page 4, para 9 of my written submissions. My lord, the extract, if your lordships will skip the first 10 lines and come to those who are unequal in fact. I hope your lordships have that. After 10 lines from the top. Equality, which must cover every process of equalization. Or shall I read it from the top of the...
That's fine. Those, we got it actually. That's the correct extract. Those who are unequal in fact.
Yes, yes. And later, those who are unequal, in fact, cannot be treated by identical standards. That there may be equality in law, but it would certainly not be real equality. Existence of equality of opportunity depends not merely on the absence of disabilities, but on presence of abilities. It is not simply a matter of legal equality. De jure equality must ultimately find its raison d'etre in de facto equality. The state must therefore resort to compensatory state action for the purpose of making people who are factually unequal in their wealth, education, and social environment equal in specified areas. It is necessary to take into account de facto inequalities which exist in the society and to take affirmative action by way of giving preference and reservation to the socially and economically disadvantaged persons or inflicting handicaps on those more advantageously placed in order to bring about real equality. Such affirmative action, though apparently discriminatory, is calculated to produce equality on a broader basis by eliminating de facto inequalities and placing the weaker sections of the community in a footing of equality with a stronger and more powerful section, so that each member of the community, whatever is his birth, occupation, or social position, may enjoy equal opportunity of using to the full his natural endowments of physique, of character, and of intelligence. Now, my lord, so far as this is concerned, your lordship should note that the result of not, my lord, making a subcategorization would be that those who are already more advanced than, my lord, the weakest of the weak, which is a phrase which has been used, my lords, by Justice Krishna here, the weakest of the weak will fall to the ground, and those who are more advanced will take the lion's share, so that this reservation is meaningless and has no effect whatsoever in neutralizing the disadvantages which were sought to be cured by, my lord, the reservation. Now, in this connection, my lord, the words of Justice Krishna here in N.M. Thomas has been extracted at page 9 of my written submissions.
Yes.
And your lordship should be pleased to say at page 9, para 28, the extract from State of Kerala versus N.M. Thomas, page 363 of the judgment, para 124, innovations in administrative strategy to help the really untouched, most backward classes also emerge from such social legal studies and audit exercises of dispassionately made. In fact, research conducted by A.N. Sinha Institute has revealed a dual society among Harijans, a tiny elite gobbling up the benefits and darker layers sleeping distances away from the special concessions. Therefore, my lord, the Harijans are, my lord, the most backward classes among the scheduled castes, a dual society among Harijans, a tiny elite gobbling up the benefits, and the darker layers sleeping distances away from the special concessions. And that is what, my lord, the state of Andhra Pradesh sought to do, which was reversed, my lords, by the Supreme Court of India. My lords, your lordship will find the citation at the bottom of that page of Jarnail Singh versus Lakshmi Narayan Gupta, 2018, 10 SCC 396. This is a 5 judges bench presided over by Justice Rohinton. And there, my lords, I had argued as Attorney General that E.V. Chinnaya would stand in the way of the principle of the creamy layer, which was upheld for OBCs in the Indira Sani judgment from being applied to scheduled castes. And therefore, since they are only one homogeneous class, you can't subdivide it and remove some of them. Now that was rejected, and the same entire judgment focuses on what was held in N.M. Thomas. And following that, their lordships held that so far as the creamy layer is concerned, they have to be excluded even from the category of scheduled castes. The result of this is that a constitution bench of this honorable court has already taken the first step forward by Briggs dissenting from Chinaya to the extent that they have said that a subclassification can be made.
Yes.
I may mention, my lords, that after the judgment in Chinaya delivered by the Supreme Court of India, the government of India, Union of India, wanted the whole issue of subclassification to be, give me that one. The entire issue of subclassification to be gone into by, my lords, the committee, and for which, my lords, Justice Usha Mehra was appointed then by the central government, and which constituted a national commission to examine the issue of subcategorization of scheduled castes in Andhra Pradesh with Justice Usha Mehra as chairperson. This was, my lords, on 16th of November 2006. And the judgment in Chinaya's case by the Supreme Court was on the 5th of November 2004. Now, Justice Usha Mehra went into the issue elaborately, and her report is at page 345 and goes on to 506. And finally, my lords, where do you find it?
Volume 3A,
It is in volume 3, capital A, my lords,
page 446,
at page 504,
446, then
at page 446.
this page is 446. It begins at 285.
It begins at 285, my lords, in your lordships.
Page 446. Three.
No, what is this?
444.
And if your lordship should be pleased to go to page 44,
444.
444. Para 33.
Volume 3A, page 444. Volume 3A, page 4.
Volume 3A,
Page 444.
page 444. This one.
Actually, our PDF, page 447.
Paragraph 23.
33 minutes. Repeat it.
Page 444. Of volume.
Volume 3A, page 444 minutes. Is para 33.
This is for subcategorization.
The analysis of data, your lordship about it?
Mr. Venugopal, we read that actually. We've seen that.
Yes. Para 33.
Anything else, Mr. Venugopal?
Yes,
Or-
no, I am closing with this. Please see, my lord,
46.
page 446,
Yes.
para 37. The commission thus recommends that Article 341 of the Constitution of India be amended and clause 3 thereof may be added as under 341 clause.
It's a clarificatory amendment, actually.
Yes.
A clarificatory amendment.
By law provide for subcategorization,
It was eventually never made.
subcategorization of caste so and so within any caste, race or tribe.
Your argument would be that even in the absence of such an enabling provision, the power is always there in the state.
Well, that is what way I had relied strongly on Article 38(2), which mandated that your lordships would ensure, my lords, that even individuals who are oppressed or suffer from disabilities as against their similarly placed persons should be given, my lord, equal treatment. Therefore, Chinnaya in saying that it's homogeneous, it can't be broken up. It can't be the more weakest of the weak. We'll have to suffer total deprivation so that whatever benefits are being given really is a rope of sand, as Chief Justice Chandrachud delivered it. That I submit has to be neutralized.
Thank you very much. Thank you, Mr. Venugopal. Mr. Attorney General, would you like to open? Yes.
Volume 1K, I think, is my written submissions. I'll quickly read. There are only a couple of paragraphs in N.M. Thomas and Chinnaya, which I may like to draw your lots of attention later.
Volume 1A, right?
1K.
That has not come.
Acha.
It is on the screen.
To go to?
On the Lord's have that.
Yes, we've got it on the screen here.
Let me quickly take a look at
And after all of you will also have learned attorney submissions on your screens there,
shared with all.
on the screen before you got it.
Well, the field assigned to Article 341 and 342 and the Equality Charter contained in Articles 14 to 16 are distinct. The domain of Article 341 and 342 is confined only to the identification and enumeration of scheduled castes and scheduled tribes for the purposes of the Constitution. What shall be done to effectuate the purpose of the Constitution is not a matter that will fall under the domain of Article 341 and 342. Notification in Article 341 and 342 is the foundation by devising provisions of advancement with the meaning of Article 15.4 and equality of opportunity and provisions for reservations with the meaning of Article 16.4. That is why Articles 341 and 342 talk about specification of castes, race, tribes, or parts of groups within castes for the purpose of the Constitution. This means all purposes of the Constitution in relation to scheduled castes and scheduled tribes. Except where there are express constraints, no dissonance between two constitutional provisions should be either suggested or accepted. Therefore, Article 341 is not to be seen as a limitation or a constraint in what can be done or what needs to be done under the Equality Charter of the Constitution, Articles 14 to 16. The dynamics of equality of opportunity and advancement measures will lie in the domain of Articles 14 to 16 and may not be controlled by the mere enumeration authority given under Article 341, 342. The spread of equality of opportunity and the distribution of equality measures are essentially matters that will be addressed by the state and not by the president. The E.V. Chinnaya is premised on the understanding that all the castes and tribes once notified constitute a homogeneous class, except the fact that disparate social groups designated as castes or tribes are described as scheduled, there is no homogeneity amidst them in a sociological sense. Mere clubbing of distinct castes or tribes by itself will not render them homogeneous. As long as amidst these castes or tribes, there is no uniformity of status, position, or social attainment, there can be no homogeneity. They continue to be distinct social groups or sections of the community. Each one of them constitute distinct segments deserving distinct constitutional treatments. The homogeneity, if any, compared with the non-scheduled section of the community cannot be of any consequence. The distinct constitutional treatments will always remain subject to be addressed under the Equality Charter of the Constitution, Articles 14 and 16. The constitutional treatments that the state may devise to address the concerns of one or more of the enumerated scheduled castes or tribes will always depend upon a relevant inquiry on the need and expedition required. The fact that parts of or groups within castes, race, or tribes can also be notified is an indication that the enumeration itself will be based on the connection between enumeration and the purposes of the Constitution. The question, however, as to whether such measures of advancement under Articles 15 and 16 constitute a fair spread of measures of advancement and inter se not discriminatory will be an independent inquiry entirely unconnected with Articles 341 and 342. The obligation on the part of the state to ensure fair and non-discriminatory availability of the measures of advancement will always be tested on relevant grounds. It is also expected that the state will act fairly in this regard, will not be partisan, and will not arbitrarily exclude anyone on the enumerated list from the fruits of advancement measures. The power given to the Parliament under Article 341(2) is also confined to the domain of enumeration, and the authority to include in or exclude from the list notified cannot be equated to the power of the state under the Equality Charter of Articles 14 and 16 of the Constitution of India. The Constituent Assembly debates on Article 16(4) show that the framers decidedly used the expression backward classes in plural to comprehend all social groups, including scheduled castes, which can be considered backward on certain common criteria and aspects. The 9th decision in Indira Sani has elucidated the understanding. No doubt can now be raised as to the comprehensiveness and inclusiveness of the expression. To the extent discussed above, it can be said that E.V. Chinnaya has frozen all state authority or authorities of the states under Articles 14 to 16 of the Constitution. Whether it is in tune with the constitutional dynamics is a question that deserves to be answered. E.V. Chinnaya does not answer many questions raised above. It is built on the premise that all enumerated castes and tribes can and must collectively enjoy the benefits of reservation, regardless of inter se inequalities, and that any subdivision will dilute collective identity and rob the fruits of collective emancipation. This broad statement has no demonstrable truth in empirical terms and is certainly not supported in the judgment itself. The E.V. Chinnaya holding that homogeneity of those in the state of Kerala is open to question. I don't propose reading several paragraphs in it. I'll just point out 2 or 3 paragraphs of Justice Thomas and Justice Krishnaya in a short while. Articles 14 to 16 constitute a triumvirate of citizens' rights and state obligation. They've been conceived as equality and social justice charter, guaranteeing both right towards emancipation from social, educational, and economic backwardness, and non-discrimination all walks of life under state transactions. The state has a corresponding obligation to devise measures and methods, fashion policies and tools to regard, promote, and protect these rights. The enabling nature of Articles 15 and 16 are instead of duty coupled with power. Any undue limitation on both duty and power in the context of these provisions will be constitutionally suspect. The court has delineated several facets of these rights and also declared in the interplay between these rights. The equality rights in Article 14 and equal opportunity rights in 15 to 16 have mutually reinforcing facets. The evolving dimensions of these rights, in consonance with changing social and economic aspects, have been carefully crafted over a period of time, both by legislations and judicial pronouncements. The obligation of the state and the states to undertake emancipation of the deprived and weaker sections of the community, the obligation to eradicate inequalities in status and wealth, are complex obligations involving redistribution and reallocation of resources and opportunities, and equitable access to all public and social goods. Education, health, and public employment are all public goods of immense value, facilitating citizen participation in the affairs of the state on an informed and equal basis. The states will therefore always need the freedom to carry out informed experiments without being fettered by undue or disproportionate claims. There are no and cannot be any textbook answers or precedents of perennial value and relevance which can guide the state or the states as regards the roads to be traveled or measures to be taken to promote fundamental rights. The court too will bear the social dynamics in mind and be careful not to chain the state or clamp its hands while interpreting constitutional provisions. Rule of law also demands that the state is able to harmonize and balance several competing claims and interests. I'll just take a couple of paragraphs in Enam Thomas.
Just give us the paragraphs, Mr. We'll have a look at them because those have been read out.
No, you.
Give us the volume and page, that's all.
Enam Thomas, Volume 5.
Volume 5. Which paras?
Paragraphs 53 and 54. You'll just turn to PDF page 26. I just probably read it from the head note to give those references.
53 and 54 and then,
Justice Matthew's judgment
right,
at page 26. There are two paragraphs referred to there.
and
Paragraph 53 and 54 bracketed together.
anything more? Which other para? भी नहीं पढ़ेंगे यार, बहुत हो गया.
NM Thomas has been read to us many, many times.
Paragraphs 53 and 54. This PDF page 53 is the PDF page or 57. Paragraph 53.
Seven. Correct? Yes. Paragraph 53 and 54.
57. Look at paragraph 53.
And 54.
Para 53, para 54.
Yes,
Proportional equality.
that's right. Formal
Formal
equality.
Formal equality, proportional
Just
equality.
is the third line, but men are not equal in all respects. The claim for equality is in fact a protest against unjust, undeserved, and unjustified inequalities. So going a little down in the same paragraph, last line, we therefore have to resort to some sort of proportionate equality in many spheres to achieve justice. Then the next paragraph, the principle of proportional equality is attained when an equal so and so. This will raise the baffling question, equal and unequal in what? The principle of proportional equality therefore involves in appeal to some criteria in terms of which differential treatment is justified.
There are various terms used in the various judgments in
Yes.
That's right.
in NM Thomas. It has also been decided as a compensatory discrimination.
That's right. Back to and also paragraphs 81 and 82. Let me make a note of that. 81, 82, again, Justice Thomas' judgment.
82.
Yeah, 82 now.
PDF page 65.
Yes. This has already been argued, Mr. E.
Yes.
Yes.
You have made a note in your.
Then paragraph 141 of Justice Krishnaya judgment at PDF page 86.
Thank you, Mr. Attorney General. Thank you so much.
Yeah, the paragraph begins at the basic question.
Yes, we'll have a look at it, Mr. Attorney. Thank you so much.
That's right.
Anybody else now who would like to, Mr. Solicitor is here?
In Chinaya, paragraph 113 of Justice Sinha judgment, just kindly look at that.
Yes.
This is PDF page volume 5, page 815.
Sinha J, paragraph,
113.
page
PDF page 819.
PDF page 8. We'll have a look at it, Mr. Attorney. We'll have a
PDF page. Just look at the paragraph. The power of the state legislature to decide as regards grant or benefit of reservation so and so is not in dispute.
Yes.
Furthermore, not in dispute that if such a decision is made, the state can also lay down a legislative policy as regards the extent of reservation to be made for different members of the backward class, including scheduled caste. But it cannot take away the state benefit on the premise that one or the other group among members of so and so has advanced and thus is not entitled to the entire benefit reservation. That begs the question.
Thank you, Mr.
That's right.
Thank you, Mr.
Please,
Mr. Solicitor.
I'll not take more than 10 minutes, my lord. I'll bear in mind the distinction between a person, my lord, who has something to say and a person who has to say something. My lord, it is very ably argued by, my lord, all my predecessors, my lord, and especially the learned Advocate General. My lord, please take my volume 1I. It's a 15-page note. I'm not going to read the entire.
It has come on the screen, yes. It has
It
not,
is there, my lord. Your lordship would find it at one.
it is
It's here.
here on the
Sorry.
screen, yes.
My lord, what I have done is, my lord, I have given a history which I am again not going to place before your lordships
Yes.
as to how this developed. But the most relevant part is, slowly and gradually, your lordships on the judicial side has started taking note of the fact that there needs to be some rationing.
Right.
At the outset, I say, my lord, on behalf of the central government, my lord, it is not my submission about the reservation. Reservation as a policy, the central government is committed to. My written submissions, my lord, are only confined to the question referred whether there can be a sub-classification or not.
Right.
And sub-classification as a concept was bothering your lordships, my lord, and there are some judgments which reflect that, my lord. Lord, please see page, Lord, 1. It starts with, my lords, the Chief Justice recently said, my lord, Champakam, my lord, I am not going into that, my lord. Thereafter comes Balaji. Balaji says that this is an exception to 15 and 16(1). And thereafter, which is changed in N.M. Thomas, my lord, which says that it's not an exception, it's an equality thing. Lord, thereafter, your lordships may kindly come to M. Nagaraj, my lord, which is at page 3. In M. Nagaraj, in my respectful submission, this question, my lord, started bothering your lordships, whether there needs to be some rationing so that the real beneficiary gets the benefit. Lord, please come to para 10. Thereafter, the judgment in Nagaraj was referred to a 5-judge bench to examine the correctness on 2 counts. Lord, first, your lordships can skip B. Second, being whether the concept of creamy layer can be made applicable to the scheduled caste and scheduled tribes. So those who are taking the majority of the benefits and depriving the more backward, should that concept come in or not, my lord? Lord, thereafter came, my lord, Jarnail Singh. Please come to page 12. And I have quoted, my lord, the relevant part, para 12, my lord, I'm sorry, page 4, para 12. The judgment in Jarnail Singh refers to the broader object of amelioration of backward classes and clarifies that this cannot be achieved if only the creamy layer within that class bag all coveted jobs in the public sector and perpetuate themselves, leaving the rest of the class as backward as they always were. Lord, thereafter comes, my lord, Lord Jaisri, Lord, recent judgment, my lord, Maratha reservation judgment, my lord, where, my lord, your lordships have said that, have, my lord, reiterated that Constitution is always an evolving document, and therefore we will have to answer to the needs of the hour. My lord, I am just placing it for your lordship's consideration. I am not reading it, my lord, because it gives a broader perspective how your lordships would view a constitutional provision which is, my lord, for the betterment of the backward classes. Lord, then, my lord, I have, though that's not the question referred, Lord, just by way of an abundant caution, I have, my lord, at page 5, given finality of Article 341, which remain unaffected, my lord. Lord, even if your lordships were to take the view that subclassification is a permissible mode, my lord, that also would be as per the same constitutional route as prescribed. The state would recommend to the president, then thereafter it will go to the parliament, and parliament will decide whether to put it in the schedule or not, my lord. That's not the question, but by way of abundant caution, my lord, I have placed it for your lordship.
According to you, sub-classification will have to be done only by the parliament.
Yes, ma'am. No, my lord,
No.
it's
It can be done even by this,
identification by the state.
by parliament.
Yes, my lord.
And-
What is happening now?
Implementation by the states.
By the state again. What happens, my lord, now, one caste is identified as a scheduled caste. It's only identification by the state. It comes to the President of India, then goes to the Parliament, and thereafter, after parliamentary legislation, that caste is notified for that state as a scheduled caste, and thereafter implemented by that state. So, my lord, that is not the question, but by way of abundant caution, my lord, I have quoted, my lord, Basav Lingappa, that 341 is absolute, my lord, and state of Maharashtra versus Milind. My lord, I am not reading it because that's not the question my lords are, my lord, considering. But, my lord, now kindly come to page 11, my lords. Ashok Kumar Thakur, my lord, this is 2008, where almost, my lord, your lordships were bordering on this issue, which your lordships are, my lord, considering now. Para 6 and 9. Reservation is one of the many tools that are used to preserve and promote the essence of equality, so that disadvantaged groups can be brought to the forefront of civil life. It is also the duty of the state to promote positive measures to remove barriers of inequality and enable diverse communities to enjoy the freedoms and share the benefits guaranteed. My lord, thereafter, please come to, my lord, M. Nagaraj, page, para 23, my lord, page 11. Para 48 is relevant, my lord, at the foot of that page. It is the equality in fact which has to be decided looking at the ground reality. Balancing comes in where the question concerns the extent of reservation. If the extent of reservation goes beyond cutoff point, then it results in reverse discrimination. Anti-discrimination legislation has a tendency of pushing towards de facto reservation. Therefore, a numerical benchmark is the surest immunity, etc., etc. Lord, please then come to N.M. Thomas. Lord, this is quoted in Jarnail Singh, para 124. A word of sociological caution. In light of the experience, here and elsewhere, the danger of reservation, it seems to me, is threefold. I am not arguing against the reservation. I am just not flagging the sub-classification issue, because sometimes we are likely to be misunderstood intentionally or unintentionally. Its benefits, by and large, are snatched away by the top creamy layer of backward class, caste or class, thus keeping the weakest among the weak always weak and leaving the fortune layers to consume the whole cake. Yes. Your lordships, my lord, flagged this for the first time. Justice, my lord, Justice Krishna Iyer, my lord, flagged it, which is now followed by the recent judgment in my lord Chelbro Leela Prasad Rao versus State of Andhra Pradesh. My lords would find it at page 13. Para 165, your lordship gets one. In our, my lords get them.
Yes.
In our opinion, it was rightly urged by Dr. Rajiv Dhawan that the government is required to revise the lists. It can be done presently without disturbing the percentage of reservation so that benefits trickle down to the needy and are not usurped by those classes who have come up after obtaining the benefit for the last 70 years or after their inclusion in the list. Lord, thereafter comes, not in point of time, Lord, in my chronology, R. Chitralekha. This interpretation will carry out the intention of the Constitution expressed in the aforesaid articles. It helps the really backward classes instead of promoting the interest of individuals or groups who they belong to a particular caste a majority whereof is socially and educationally backward, really belong to a class which is socially and educationally advanced. To illustrate, take a caste in a state which is numerically the largest therein. It may be that though a majority of the people in the caste are socially and educationally backward, an effective minority may be socially and educationally far more advanced than another small subcaste, the total number of which is far less than the minority. If we interpret the expression classes or castes, the object of the constitution will be frustrated and the people who do not deserve any advantageous aid may get it to the exclusion of those who really deserve. This anomaly will not arise if without equating caste with caste, etc., etc. My lord. Your lordships, my lord, then come to, my lord, it was, this Vasant Kumar was read by, my lord, the learned AG. My lord, I am not therefore repeating. My lord, on page 15, I have given, my lord, my propositions, my lord. There are four propositions. I am not, my lord, going to read. I am just placing it for your lordship's consideration. This is again, my lord, at the cost of repetition, only to answer the constitutional question whether subclassification is constitutionally permissible, but not against reservation in any form.
Thank you, Mr.
Lord, Mr. Agarwal is appearing for Chandigarh administration. Lord, he may be given some time. Lord, maybe after.
Should we hear Mr. Nafde right after lunch?
I will start after lunch.
After lunch, because we're almost at the stroke of 1.
Very well. I'll be very.
We had actually planned to complete this side by 1, so we'll.
I'm also.
That sense, eating into the time of the others.
I'm also there, minutes. I may take 5 minutes, Venus. I'm also there.
Census for Haryana have to be submitted. Only 5 seconds. After Tamil Nadu.
We'll hear Mr. Nafde right now.
At 2 o'clock we start.
Grateful to you.
Yes, Ms. Nakuru.
Sir, I appear for state of Tamil Nadu, item 701.9.
701.9.
This is a transfer petition from Madras High Court. So the challenge is to our law known as Tamil Nadu Arundhatiya Special Reservation of Seats in Educational Institutions, including private educational institutions and appointment of posts in services under the state.
So, Mr.
2000.
Napde, once we decide on the correctness of Chinaya, there may be other challenges to the validity of the act.
Undoubtedly,
That
this
we
will
have
have
to
to
go back
High
to the,
Court.
that's,
But if your lordships hold that there
but
can't
Chinaya
be
is
some
right, then the
classification,
law goes
matter will
straight,
come to an
then
end.
the law goes
No
out.
problem.
That's right.
No problem. Now, let me first begin with on a little bit of a philosophical note. Marx said about more than a century ago that history of all hitherto existing societies is the history of class conflict. But in a democratic setup, we must have an organized legal system which can resolve this conflict. And today your lordship sees in several parts of the country, there are conflicting interests amongst the scheduled castes themselves, or OBC, as we see in Maharashtra now. Now the problem is how to resolve this. Now, what is the legal mechanism? One is the reservation policy. The state of Tamil Nadu has been vigorously pursuing reservation policy for several decades. By 2008, it came to the notice of the government, and which is reflected in the governor's address to the assembly, that though there is reservation policy in force for several years, a certain group of scheduled castes have not yet got the adequate benefit, and they are not adequately represented. This was the beginning of the enactment of this act.
What is the year of this act, you say?
2008. So the act is of 2009, but by 2008, it came to the notice of the government that certain scheduled castes have not adequately received the benefits of the reservation policy. And that is reflected in the governor's address. That led to the appointment of a committee of a retired High Court Judge, Justice Janarthanam, which collected the empirical data and came to the conclusion that a group of scheduled castes known as Arundhatiyas have received practically nothing, and therefore something is required to be done. This is how the 2009 Act is enacted.
Arundhatiya is one community?
2009.
Is it one community or?
Once
It's one community.
It is an umbrella term.
a
That's
large
fine. Or is it an
community.
umbrella term?
It consists of group of scheduled castes out of 76. Out of about 76 notified under Article 341. Yeah. Now let me begin with what is wrong with Chennai. So I have identified 7 errors which I will quickly enumerate. First is interpretation of Article 341. Now, Article 341 only empowers the president to notify and identify and notify the scheduled caste. Thereafter, the legislative competence of the state under Article 246 read with Schedule 2 and Schedule 3 gets triggered.
Thereafter?
Thereafter, the state's legislative competence under Article 246 read with Schedule 2 of the 7th Schedule, List 2 of the 7th Schedule, and the List 3 of the 7th Schedule get triggered. Read with Articles 15.4 and 16.4. Now, all this constitutional scheme permits the states to enact a law And your lordships are aware that the executive power is coextensive with the legislative power. In Balaji's case, your lordships have already held that to make reservation policy, it is not necessary to enact a law. It can even be done by an executive fiat. Now, what Chennai holds is that subclassification is inconsistent with Article 341 notification. Now, the wording of Article 341 and the conclusion that the subclassification is inconsistent with Article 341, there is no connecting link. See, in the process of ratiocination, you take a proposition and derive another proposition, then derive another proposition, and then come to the conclusion. That's the logical way of looking at things. Now, straight away that because 341 empowers the president to notify a list of scheduled castes, you cannot straight away jump to the conclusion that subclassification is inconsistent.
No, I think what the logic, I mean, that's a correctness which falls for determination. The logic was that yes, that Article 341 is the process of designation or notification, as you call it. But once notified, all of them comprise one group of scheduled castes.
That comes to homogeneous. I'll come to that part.
Right.
Because
And
that is one of the
therefore-
grounds.
Right. And therefore, since it is one composite group of scheduled castes, therefore, if you give reservations in a state, you must give it to all of them. That's the logic of Chennai, I think.
Now, that would be inconsistent with Article 15.4, 16.4. These are enabling provisions.
So is that the
Now,
second
that's why,
point?
therefore, I demarcate the legislative competence in two different aspects. One, the power to notify a particular scheduled caste under 341, that is exclusively with Parliament, no difficulty on that score. Now, from that list, which is given to the state, who should be the beneficiaries? Article 341 doesn't deal with it.
Just one second.
It stops at that.
That's what the learned Advocate General argued.
Correct,
that
correct.
Chennai has to take into consideration the interplay between Article 341 and 16.4.
So therefore, Article 341 is merely a fetter on the state's power to identify a particular caste as scheduled caste. And it stops at there. Thereafter, it is for the state to decide. Yes, yes, same argument, but I am putting it ultimately in law. Your lordships are aware, the elephant and the blind man. Everybody looks at it from a different
But
perspective.
fortunately, on this side, from the arguments which are advanced so far, it looks that everybody looks from the same eyes.
My lord, in Tamil Nadu, recently, the similar replaced caste are enacted act by the parliament itself. So it itself proves that state government has full power. So it's the same state government enacted.
Fair enough, fair enough. Now, Mr.
We'll hear you after
Here
this.
we are. 1 second. We're in the midst of a constitution bench, yes.
Now, my second limb of argument on this core is that court is reading into Article 341 some words which do not exist in it. The court is adding words. And the last limb which my Lord Chief Justice said just now, that Chennai proceeds on the assumption that it's a homogeneous class, and therefore if the state decides to grant benefit of reservation, then the state must grant to all the scheduled castes, and the level of benefit must be same, otherwise it will be hit by Article 14. Now, this reasoning, according to me, runs counter to the basic concept of classification. Now, it is settled law that scheduled castes are also a class. Scheduled castes are also a class. And 15.4 and 16.4 deal with also class.
Now, what happened in Chennai's case, there was a report of Justice, Justice Raju. Report of Justice Raju. It collected an empirical data and came to the conclusion that a certain scheduled caste have received disproportionately large benefit. And comparatively, some scheduled castes have received practically nothing. And therefore, on the basis of that empirical data, the classification was made into A, B, C, and D. Now, this classification of scheduled caste must also pass the test of classification, which your lordships have laid down, intelligible differential, nexus to the object of legislation or to the policy.
Right.
If these two tests are satisfied, where is the question of going into subclassification? And to say that subclassification is per se contrary to Article 14. Because ultimate test is that the court has declined to go into the empirical data. On an abstract proposition that the subclassification is violative of 14. No factual foundation. The court has not applied the test of classification. The court has not made any attempt to find out whether there is an intelligible differentia or not. And if there is an intelligible differentia, whether it has nexus to the object of legislation. Complete absence of any discussion.
So once they hold that it is not permissible, then where is the question of going into the empirical data?
Correct, but
If the court comes to a conclusion.
But the premise is that per se it is violative of 14. Per se it is violative of 14. Now this is where our difference starts. Because classification, because as far as say OBC, which are not scheduled castes, if they are to be differentiated, as is done in Indra Sawhney, what is the test that we apply? Same test. Intelligible differentia, nexus to the object of legislation. So the basic test of classification is not applied.
Because they say it's per se one.
Per se. That you must grant to everybody.
Right, that's the
at
third.
The same level.
Now, what is the fourth, Ms. Nafri?
This is the last.
Now,
Yeah. Yes.
now the next ground is
That's what it says. This is the last.
that court has read into Article 341.
I'll about my number 4.
The court has read into Article 341 prohibition that it prohibits subclassification.
I'm not sure we should go there because 341 will not permit the states to make a subclassification. If the Union of India makes a subclassification,
No, for the purpose. That's
under
why
31, acting through an act of parliament, it's permissible.
No, therefore
But the
I
point
say,
really is that the actual reservation, the actual implementation of reservation under 15.4 and 16.4 stands in a different sphere as compared to the work of designation, which is exclusively under Article 3.
no difficulty on that score. But look at this, legislative competence is divided into two parts. Identification of scheduled caste, 341, exclusive parliament. Whether to grant benefit, you come to the state.
Yes, correct.
That
Now
is
the
everybody's
second-
contention. That has been consistently argued by everyone, that insofar as 341.
But Chennai says that state
Everyone
has
has
no
argued that Chennai is wrong on this.
Everybody has argued the same thing, that
No, but
Chennai is wrong on this premise, that
Chennai
Chennai has not taken into consideration that Article 341 and 16.4 and 15 act in a different sphere.
No,
The
but
the
what-
precise argument of the learned advocate general is 341 is only for the purpose of identification and designation. Once it is identified and designated, then as to what measures has to be provided for uplifting them is within the domain of the state under Article.
I agree with
4 and
there is no difficulty on that score. But Chennai further says that the state has no legislative competence.
Because
I
it,
showed to the
because it
paragraph.
comes to a conclusion that it amounts to tinkering with the
yes.
values.
The Chennai says that
Therefore, everybody's argument is the Chennai
they say no
went
legislative
wrong in holding that.
competence.
That's right.
Now, I just want to indicate to your lordship the relevant entries from these three of the 7 schedule. I'll quickly enumerate those lists, my lord, those entries. Entry 25,
But why do you need to go there? 16.4 itself says that the state has to implement the backward, backward on provide reservation.
I'm only trying to show the entries. Because the reading of Chennai,
Entry 25 is education. List 3 is
25,
education.
26, then entries 5, 41 of the state list,
And
that is
dispose of
the
property.
public service,
No.
state service,
Where is it?
list 2, list 2.
List 2 state public services.
Entry 5 is local government,
Just 1 second.
and entry 20 of the concurrent list, social and economic planning.
Entry 5, then you give us entry 41.
25 and 26 deal with education of the concurrent list. And entry 20 of the concurrent list is economic and social planning. Reservation policy is therefore a part of the social. And as far
So
as state
according
list
to
is
while
concerned,
legislating
entry
under
5
article,
and 41.
entry 5 and 41.
41, 5 and
According to
41.
you, while legislating under Article 245, the state can, for instance, legislate on state public services. You can legislate on education under 25. While as an incidental part of that, you can provide for legislation
Reservation.
on reservation.
Correct.
We got the point.
Now, the next point which I wish to urge is that the social scenario is changing, rapidly changing.
7.
The social scenario is rapidly changing. Anyone who reads the daily newspaper would see that there is a sea change. Now, reservation policy, therefore, must keep pace with the social dynamics.
It should be organic and evolving, not static.
Correct. If you keep reservation policy, which was there 50 years back, it will get fossilized. It will lose its connection with the contemporary situation.
All right. What is the next point, Mr. Nafde?
The next point is, the next error which I find is the test of Article 14.
That
which I already indicated.
You have already indicated.
Intelligible differential.
Then the court has, without adequate reasons, has declined to follow Indira Sawhney. In my view, it is directly contrary to Indira Sawhney. Because if there can be sub-classification amongst the other backward classes,
Why not in this?
why not this? In logic, what is the test?
At that time, 342A was not there. When Chennai was decided,
We are
342A was not there, but 341 and 340 were there.
But we are concerned with the test of classification. The test of classification has not changed. The two ingredients, intelligible differential and nexus to those are solid rocks which have survived all these constitutional crises. And the last is the usual argument that it will affect the efficiency.
That we've heard yesterday, Mr. Farasat also argued that.
Because again, there is no logical connection between sub-classification and
Farasat rightly referred to the judgment delivered by my Lord the Chief Justice, wherein that this aspect has been discussed at length.
Now, as far as sub-classification is concerned, in Vasant Kumar, there are two paragraphs which I want to invite your Lordship's attention. One is para 22. and there is para 55.
Vasant Kumar,
Vasant Kumar's case in 1985, supplement SCC.
which, where will you get it in the compilation? Volume 5,
It is in volume 5.
page 1114. What are the paras, Mr. Nafade?
The 1114, 1985,
And paras?
para 22 and 25. 22. I'm sorry, 25 and 55. I stand corrected.
And what is the point that,
The point is this, I am just reading the one line from that para 25.
yes,
The assumption that all members of the same caste are equally socially and educationally backward is not well founded. Such an approach provides an oversimplification of a complex problem of identifying the social and educational backwardness. And para 55. Para 55 in terms says that there can be subclassification. This,
can you just read out that one sentence where it says that? Para
Which one?
55. Para 55.
para 55, I'll just read it out. This is what it says.
The first paragraph is.
A result of the subclassification was that nearly 90% of that is, their lordships are referring to Balaji. The propriety of such a course, so I must state the background of behind this paragraph. In Balaji, question of subclassification was not the main issue. The main issues were whether reservation can be done by an executive order. Second issue was whether caste itself can be a criteria for classifying. These were the two issues. Incidental reference was made to subclassification, and they found that the criteria which was adopted in Balaji's case, that nearly 90% of the population became backward. That was found to be bad. But there is no direct discussion about subclassification. So this is, in my respectful submission, not a ratio at all, not even an arbiter, because issue
What
is
does
not
Vasant Kumar say in para 55?
Now, this is what they say in the context of Balaji. A result of subclassification was nearly 90% of the population of the state was treated as backward. The propriety of such a course may be open to question on the facts of each case, but we do not see why, on principle, there cannot be a classification into backward classes and more backward classes. If
All right.
both the classes are
Just read the last sentence of this paragraph, last sentence, that's the crux of it.
last two lines.
All that we can say is.
All that we can say is that subclassification may be permissible if there are classes of people who are definitely far behind the advanced classes, but ahead of the very best.
Because a matter of principle, there is no constitutional bar.
That's the
You
point.
got the point.
So
Anything else, Mr. Nafade, we'll have to get on now. Thanks.
So the point ultimately is this, that whether my subclassification
Got the,
stands the scrutiny of classification test.
be that.
Otherwise, the different groups of scheduled castes, they are unequals and therefore they can't be treated equally.
Thank you, Mr. Nafade.
The
Mr.
Thomas
Gupta,
principle.
Mr. Gupta.
Minutes, it's maybe my turn, minutes. I have
One second. We've got an order here. Yes, Mr. Neeraj Gupta.
One last minute. So the state has been following this policy very vigorously, and therefore state has vital stakes.
Certainly.
I'm mindful of the mood of the court, Millets, and I'm mindful, Millets, also of time constraints, so I will not repeat Millets. First submission is, Millets, that Chennaiya is bad in view of the constitutional scheme, and I have 4 submissions on that, Millets. Four reasons why Chennaiya is contrary, Millets, to the constitutional scheme. Number 1, Millets, the constitution uses the expression scheduled caste, scheduled tribe, socially and educationally backward classes in various provisions, Millets. Your Lordship may make a note, Millets. Articles 15.
1 second. Constitution uses the expression
Scheduled caste, scheduled tribe, and socially, educationally backward classes.
in
Millets, Article 15. Partly in Article 16(4)(a) and 16(5) Millets, 16(4)(a). Then Millets 46,
164. It speaks of Millet's scheduled caste and scheduled tribes in articles 243D, 243T, T for Tamil, 330, 332, 334, and 335. It refers to National Commission Millets for Scheduled Caste, Scheduled Tribe backward classes in 338, 338A, and 338B. It also refers, millets, to scheduled tribes in 339, to millets, backward classes, SCBC in 340, and lastly, millets, the definitions under 366, namely 24, 25, and millets 26C for SC, ST, and SCBC respectively. It is only, millets, in 16.4 that the expression used is backward classes. And well settled, para 787, Indra Sani, that backward classes here covers scheduled caste, scheduled tribes, and SCBC. Therefore, intent, millets, of constitution framers was that backward class under 16.4 is a category where they are all at par. Because it is an expression used singularly in 16.4, not in 15, not in 16.4a, and not, millets, elsewhere. But the intent being that for the purpose of backward classes under 16.4, SC, ST, SCBC are at par. Therefore, millets, the rationale of Indra Sani, Kwe, SCBC, OBCs should squarely apply. Here is my first submission on constitution. Number 2, millets.
1 second. Yes.
Now kindly take, millets, Article 15 and 16 with me for a moment, millets.
Yes.
I now want to show the words preceding scheduled caste, scheduled tribe, SCBC, and backward classes used in these articles. And my submission is, if your lordship kindly takes, millets, 15.4 first. 15.4 says, nothing in this article or clause so-and-so of 29 shall prevent state from making any special provision for the advancement of any socially, educationally backward class of citizens or for scheduled castes and scheduled tribes. Now, millets, it could be argued, as was being debated yesterday, whether any is a prefix to socially and educationally backward class of citizens alone, or is it also, millets, scheduled caste and scheduled tribes?
Prima facie, only the former.
Only the former. Otherwise, millets, they could again have been clubbed together like in 16.4. I bow to that. And importantly, when it comes to scheduled caste and scheduled tribes.
I'll tell you why it qualifies only the former.
Yes.
Because for is used twice.
Yes.
If they wanted to apply the word any to SC/STs, they would have said for the advancement of any socially and educationally backward class of citizens or scheduled caste or scheduled caste and scheduled.
I bow to that. So my submission is that where they wanted, millets, to use the word any, they have specifically said that who is socially and educationally backward.
Right.
And then they go on to say for the scheduled caste and scheduled tribe, millets, in 15.4.
Yes.
Similarly, 15.5.
Yes.
Similarly, 15.5. Now, when we come to 16.4, now here, your lordship, as your lordships have already noticed yesterday, nothing in this article prevents the state from making any provision for the reservation of appointment or post in favor of any backward class. So specifically, millets, the constitution permits making of any provision for any backward class, which considerably, millets, includes scheduled caste, scheduled tribe. Therefore, Chennaiya is in the teeth of the plain language of 16.4.
When the backward class includes SCBC, ST and SC.
Para
What was-
787 of Indira Sani specifically says so.
What was the reason of specifically mentioning all these three in 15.4?
That's what my Lord the Chief Justice just said, Milits, that because there, any is qualifying only SCBC. What fell from my Lord the Chief Justice a moment back is the answer for that. That the word any is qualifying SCBC, not qua SC/ST.
Or for scheduled caste and scheduled tribes.
Yes, Milits. So there is, any is not preceding, Milits, in 15.4, is not preceding the word scheduled caste, scheduled tribes.
But in 16.4, it says any backward class.
Any backward class. So therefore, any backward class means anybody is SC, ST, SCBC. Because backward class includes everybody. Therefore, for any of the three, you can do it. Has to be, Milits.
If your argument that any has not to be read with scheduled caste and scheduled tribe.
No, I'm saying my
16.
ladyship on
No,
point
in
15.4.
15.4.
In 15.
15.4, my Lord the Chief Justice observed.
But if that argument is to be accepted, then it will be.
Milits, I'm saying.
No, then it will have to be considered as a homogenic block.
Now, Milits, I would say this, that is a debatable issue, not relevant with this bench, Milits.
Not relevant, then why are you arguing?
No, Milits. It is relevant in the sense that the different expressions have been used.
Yes.
There is a point in this that if you don't, what fell from
The
what
best argument that is being advanced is that the interplay
under
between
15.4,
341
therefore
and
16.4. I see that.
Taken into consideration.
Milits, what I'm submitting here is this. Once 16.4 is.
I'll tell you the danger of your argument. For the purpose of this case, you may be right. But this argument will hit at any attempt by the state to subclassify for the purpose of measures
15.
under 15.4.
So I'm not
Don't
saying
want
that.
to do that.
Milits, I'm only saying this. Therefore, Milits, I did not pitch it there. What I'm saying is this. The language here.
They're dangerous, I think.
Milits, what I'm saying is this. That as far as 60.
Not touched, otherwise it will.
I'm only saying, Milits, there is a language used in 15.4, 15.5, 16.4, 16.4a, 16.6. And 16.4 is the widest, which says any backward class. And any has to therefore mean, Milits.
See, but there also, there may be an answer to what you're arguing, because when it says 16.4 says any backward class, it means any backward class into brackets, parenthesis, SCs, STs, or SCBCs, right?
Yeah.
So their argument is, when it refers to SCs, it's one composite block, not, you can't, 16.4 does not give you the power to further bifurcate what is one composite block into subcategories. That's their argument.
Yes, Milits, but I would say, then Milits, why would the Constitution use the expression backward class only here and nowhere else? Because, and then prefix with any.
Any backward class.
So Milits.
You got the point.
Now this is number two. Number three. Now just notice also, Milits, in 16.4a, the expression used is very different. Please just see 16.4a. Nothing in this article shall prevent the state from making any provision for reservation in so and so in favor of the scheduled caste and the scheduled tribe. So here, perhaps, Milits, in matters of promotion, there is a restriction being applied.
It is only applicable to scheduled caste and scheduled tribe.
Yes, only scheduled caste, scheduled tribes, and doesn't say any scheduled caste, any scheduled tribe, but uses the expression the. So, Milits, using any before 16.4 has to have some meaning, Milits, which is different from 16.4a. Similarly, 16.6 also says any economically weaker section.
Nafri was right that every blind man sees the elephant in a different manner.
This is point number 2, Milits. Now, point number 3. Milits, in Article 16 and 19, provision is used at some places and law at some places. 16.4 and 4a speak of provision, as does 15.4 and 15.5 use. And 16.6 also. 15.4, 15.5, 16.4, 16.4a, and 16.6 speaks of provision.
Provision, the word provision.
Which your lordships have interpreted to mean includes an executive order, etc. The circular, etc. is good enough.
Is used in?
It's 15.4, 15.5, 16.4,
right,
16.4A and 16.6. In contrast, law is used, Milits, in 16.3 and 16.5.
Then?
Therefore, Milit's intent was that the state should have the discretion not to require Milit something through the for a law to be passed, but just an executive order is also good enough. This is what your lordships have said in Indra Sala. That the use of the expression provision as distinct from law has to be given Milit some meaning.
That was said in Balaji also.
Yes, please. Yes. My lord may just note, Milits, para 737 of Indra Sala. Para 737 of Indra Sani allows that, mentions that. The intent being that you don't need a law, you can do it by an executive order.
Right.
That's very well settled.
Yes, please. So therefore, the use of the word which my submission is that it shows that the constitution framers wanted greater and simpler discretion with the executive. You don't need to pass a law, you can do it by an executive order.
Total discretion.
Absolutely.
Then?
So, Milad, the other parts have been covered regarding a 341 part, groups, etc. I won't repeat that, Milad. This is as far as the constitution. Now, Milad, in Indra Sani, at 6 places, it is noticed, Milad, for different issues, and I'll give your lordships the para numbers, Milad. Your lordship need not bother with opening the paper book, where, Milad, this honorable court gives discretion again to the state to decide on 6 different aspects in 6 different places. The first, Milad, is in para 709. If your lordship don't mind, Milad, opening the PDF, it's at 647 in volume 5 minutes. I'll quickly run your lordship through that.
PDF?
647, volume 5.
Page 647. PDF.
PDF. It's para 709 of the SCC, Milad, it's page 670.
Yes. Okay,
647.
647.
Yes.
My lord has para 709 minutes.
Yes.
Again, in state of so-and-so, a case arising from Andhra Pradesh division bench so-and-so adopted the same approach, upheld the identification made by so-and-so, answering the criticism that backward class commission appointed by the state government did not do a scientific thorough job. Bench observed, Malad, your lordship may come down to placitum E. Therefore, the proper approach, in our opinion, this is quoting from the High Court, Malad, should be to see whether the relevant data material referred to in the report of the commission justify the conclusions. In our opinion, there was sufficient material to enable the commission to be satisfied that the persons included in the list are really socially, educationally backward. No doubt there are a few instances where the educational average is slightly above the state average. That circumstance itself is not enough to strike down the entire list. Even assuming there are a few categories which are little above the state average in literacy, that is a matter for the state to take note of and review position of such categories of persons and take a suitable decision. Then this honorable court says we agree with these observations. This is one. Then Milad, at PDF page 671. Para 744 at the foot. 744, 745. Milad, on the issue whether reservation is exhaustive under 16.4 or whether it can go to 16.1 also. Para 744, my lords have that?
Yes.
My lord, the Chief Justice has that?
Yes.
This aspect needs to be considered in whether 4 is exhaustive of reservation. In other words, question whether any reservation can be provided outside 4. There are 2 views on this aspect. Fuller consideration of the matter whereof the opinion clause 4 is not, cannot be held to be exhaustive. It's so and so, so and so. Just turn the page over, Milad. At the top of the next page, But at the same time, one thing is clear, it is in very exceptional situations and not for all and sundry reasons that any further reservation or whatever time should be provided under 1. In such a case, the state has to satisfy, if called upon, that making such a provision was necessary in public interest to redress so and so, so and so. Then the next para, let's towards the last 4 lines of the next para. In principle, we see no basis for acceding to the said contention. What kind of special provision should be made in favor of a particular class is a matter for the state to decide, having regard to facts and circumstances of a given situation, subject, of course, to observations of the preceding paragraph. Again, discretion being given, to the state. Then PDF page 694, para 783. The topic starts in para 780, which is identification of backward class of citizens. Para 782 is also important, but that was read yesterday, so I'll come to 783. The 4th line in para 783 at page 694 PDF, SCC page 717. The 4th line. It is for the authority appointed to identify, to adopt such approach and procedure as it thinks appropriate, and so long as the approach adopted by it is fair and adequate, the court has no say in the matter on how to identify. So on this 3rd aspect, this is what your lordship said. Then page 704 PDF. Which is of the SCC page 727, para 796, 797, placitum BC. Placitum B, they too represent backward social collectivities for the purpose of 16.4. Neither the Constitution nor the law prescribes the procedure or method of identification of backward class, nor is it possible or advisable for the court to lay down any such procedure or method. It must be left to the authority to identify. Then at 704 PDF, which on the same page, at the bottom, adequacy of representation in services. In this para, para 798, the test of barium chemicals is laid down in my written submission. First 10 pages are dedicated to this. My Lord, the Chief Justice accepted that submission in Pavitra. That the opinion, I'll come when I show my written submission very quickly, I'll come to this part there. And lastly, at page 706 PDF, which is on the issue of backward or more backward. Question number 5, whether backward can be divided into backward or more backward. Your Lordship will find in para 802 at the bottom of page 706 PDF, para 802. We are of the opinion that there is no constitutional legal bar to a state categorizing the backward classes as backward or more backward. We are not saying it ought to be done. We are concerned with the question, if a state makes such a categorization, whether it would be invalid. We think not. Again, giving discretion to the state. And then at the foot of the page, so similarly, at the foot of this page, again reiterating. So these are 6 places, where discretion has been given specifically to the state. Now, if your Lordship will kindly take my written note, volume 1, page 1. I've tried not to read what has been read, I'm sorry if I read a few lines.
Where is it written?
Volume 1, page 1 is my
volume 1, page 1.
Volume 1, page 1 is
Malaj,
K.K. Venugopal.
Page 3, it starts perhaps in PDF. I'll just tell you. Malaj, it is the first written submission in volume 1, Malaj. I think starts at page 3.
Yes.
Page 3, Malaj?
Yes.
Page 6 is PDF, I think.
Page 4 PDF.
Page 4. Malaj, the first point is on this barium chemical test. And I have, Malaj, at page... my Lord is following the PDF page, Malaj?
Yes.
So that is page 6, Malaj. Page 4 is the first PDF page, right, Malaj?
Page 6 now. Yes, page 6.
Page 6, Malaj. If your Lordship will turn the page over to page 7, Malaj, barium chemical is in the lower half of the page. After quoting that paragraph from Indra Sani. And if your Lordship will come now to page 8. Para 61 and 64 are the tests given in barium chemicals. where your lordships have said, Millets, the last 4 lines of para 61, the power is executive and the opinion requisite before an order can be made is of the central government or the board, as the case may be, and not of the court. Therefore, the court cannot substitute its own opinion and the opinion of the authority, but the question is whether the entire action under the section is subjective. So, Millets, this section here had said that there should be some material to justify the opinion. Whether it is good, sufficient or not is for the state to decide. But there should be some material. And your lordship says so at the bottom, Millets, at page 6, in para 64.
Tested when the challenge comes up on to the.
I see that. I see that. Very well. So, Millets, this goes on, Millets, till page 12, Millets, of the PDF. And after that, Millets, I have come on point number 2 from page 14 of PDF, Millets. You also will find para 2 at page 14.
Historical perspective.
Historical perspective. And Millets, just come to page 15, para 25. This is from Millets Rangachari. On Millets, in para 25, what was emphasized was that they should not be just lower posts, because insofar as must be
numerical as well as qualitative.
Qualitative, Millets, and values, etc. Then your lordship may skip the next few pages, Millets, it deals with the same thing, and come to page 18, where, Millets, I have reproduced, Millets, from
Akhil Bharatiya Shoshish.
Akhil Bharatiya, Millets, Justice Krishna Iyer, para 46. Where Millets Justice Iyer says, para 46, my lords have that, please. Government moved further because real power could be shared by weakest only if the doors of higher decks were open to them, higher echelons and real controllerates, not menial levels, so on. So obviously 16.4 was not designed to get more Harijans into government as scavengers, sweepers, but officers and bosses, so that administrative power may become the common property of the high and so on, so on, so on. Social stratification, being of caste system could be undone and vertical mobility won, not by authoritative exercise, but by the exercise of shared power. And then, Millets, the next page, para 65, notices that this may take centuries and aggressive policies are required, Millets. And then page 20, Millets, Swami Vivekananda's famous quote, Millets, for Shudras. And then, Millets, page 22, where, Millets, specifically Valmikis are mentioned. Valmiki the Rishi Valmiki is mentioned. And incidentally, Millets, they have, the Valmiki 6 have taken their name from Rishi Valmiki.
All right. Thank you, Mr.
Now, Millets, just 2 more things, Millets. Very quickly.
Almost half an hour, Mr.
Very well. Very well.
Thank
Now,
you.
Millets, your lordship may see this note, Millets.
We'll have a look at it.
Your lordship, just see 2 factual things. I put very interesting data, which is as recent as, Millets, this month. If your lordship will just take, Millets, volume 5B for a moment. I have put data concerning Majbi 6. And Millets, of course, it goes back to Millets studies done in 1871, but I won't show that. I'll just show the latest. Millets, in volume 5B, it starts from page 1. It's an independent volume.
At page?
Millets, in this, at page 29 to 34, I have placed before your lordship, Millets, RTIs which we have got.
Volume 5B.
From Millets, 22 government departments, which show data from 1950 to 75. Millets, 1975 were letters issued by the government under which this 50% was provided.
All right.
After 75, Millets, what has happened till date is also provided in that, till 2006, and then after the enactment till today. And what we find is
not going to that aspect. That will be considered whether sufficient material was there or not. That's not relevant for the answer.
And I've also given percentages to show we are 39%, but we are holding less than 10%.
They are not examining the
Yes, Deshmukh. Yes. Oh, yeah, Mr. Naidu?
Yes.
Yes.
May I submit?
Yes.
There is somebody in between you and Mr. Gupta.
All right.
Why we can't wait? Millets, there's the clamor or supplication of some people, and also the title of the book.
You are appearing for whom?
Millets, I am appearing for respondent number 10 in transfer petition, that's 701.9. I have given my written submissions as well, Millets.
Where are your written submissions?
Is from the Arundhatiya community. I take 5 minutes.
Supporting the legislation or you're challenging the legislation?
he supports the reservation and the Tamil
Supports,
Nadu
right?
Act. The Tamil
You're
Nadu Act,
supporting
he
Section 4,
supports.
5 of the 2006 Act.
He is a beneficiary, 2009 minutes.
2009, okay, this is reference
Tamil Nadu Act.
Tamil Nadu.
Tamil Nadu.
So what
Under
is the
the act.
submission now? Give us the distilled essence in a minute.
Absolutely, Millets. Could I be given 5 minutes? Beyond that, I'll
Why
just,
don't you- Yes, tell us what it is.
I just give some interesting quote how our caste has shocked even Martin Luther King. He has an interesting incident. Millets, I'll just narrate and just give only the gist. I won't be referring to anything
All right.
except 2 paragraphs that have to be read. One from Martin Luther King, then the other one is Isabel Wilkerson, the caste. These are the 2 things, Millets. May I submit?
Yes.
Millets, in his book, Millets, Why We Can't Wait, that's of 1963, page 147. I'll give the
Page 147 of,
Millets, Martin Luther King's classic book, Millets, Why We Can't Wait.
where is it available?
Millets, I'll give that. Millets.
Oh, you're going to give it all.
Yes,
It is not included in your submissions.
Millets, whatever I've given in that one has already been repeated. I don't get a chance if I go for that one.
So just for getting a chance, you want to read
No,
something which is not.
I would like to underline the importance of the issue.
All
Because Millets,
What
we've
did he
been
say? Let's
grappling
see
with the
that.
issue of classification or subclassification.
All right, let's read
My
that.
humble submission.
Read it out.
Yes, Millets. Whenever this issue of compensatory or preferential treatment for the Negro is raised, some of our friends recoil in horror. The Negro should be granted equality, they agree, but should ask for nothing more. On the surface, this appears reasonable, but it's not realistic. But it's obvious that if a man enters the starting line of a race 300 years after another man, the first would have to perform some incredible feat in order to catch up. Millets, taking cue from this one, Millets, Lyndon Johnson, the very next year, Millets, in his commencement address of Millets, Harvard University has said this, Millets, which is relevant for us. You do not wipe away the scars of centuries by saying, now you are free to go where you want to. Do as you desire and choose the leaders you please. You do not take a man who for years has been hobbled by chains, liberate him, bring him to the starting line of a race, saying you are free to compete with all others and still justly believe you have been completely fair. This is the next and more profound stage of the battle for civil rights. We seek not just freedom, but opportunity, not just legal equality,
All right,
but
thank
human
you.
ability.
Thank you, Mr. Naidu.
May
Thank you.
just minutes.
Yes.
Now, Millets, kindly have a look at the act.
What is the submission?
Millets, the act has never classified or much less has it indulged in any subclassification. Millets, it's only one provision, Millets. which is
4-5.
Volume 4.
Tamil Nadu would be different.
I'll just read that, Millets, for
Yes,
your
yes.
consideration.
4-5
Just
to Punjab.
1 minute, Millets. The Millets, kindly, at
What
page
is-
760, volume 4.
760?
Volume 4, 760, page number.
Volume 4,
Millets, page 760.
PDF page.
PDF. Millets, I wonder whether it's PDF page. It's a continuation page, Millets. What could be this? Huh? PDF page 761 Millets, I'm told, or could it be 765? 765 perhaps. Section 2. It's a 2-page enactment, or rather 1-page enactment.
Two.
My Lord Scott.
Yes.
Now the government of Tamil Nadu has enacted Act 4 of 2009, thereby offering reservation to Arundhatiyas on preferential basis within the reservation available for scheduled castes, and the said act came into force with effect from 29/4/2009. In pursuance of the above act, the roster prescribed in the government order, third read above, etc., etc.
Which is the statutory provision? Which is the provision?
Millets, may I come to 756 Millets? Yes. My lords got it?
756.
Yes, please. PDF page perhaps 761.
Yes.
Millets, section 3.
Yes.
Notwithstanding anything contained in the 1994 Act or 2000 or the 2006 Act or any other law for the time being in force or any judgment, etc., etc., having regard to the social and educational backwardness of Arundhathiyas, including the scheduled caste, 16% of the seats reserved for the scheduled caste shall be offered to Arundhathiyas if available in respect of annual permitted strength in each branch or faculty for admission, etc., etc. The same thing applies in 4 also, Millets. Millets, first my submission is this, Millets.
It's on a similar.
It's an umbrella
pattern of
term,
Punjab Act.
not a particular caste has been done. It's an umbrella term having about 7 castes included in that one, Millets. And Millets, for the last 2009 means Millets, up to 2023, thousands have been uplifted thanks to this enactment. And Millets, in fact, the committee that has recommended has taken the data.
Of each matter. So we are only here to answer the question of law.
Yes, Millets.
As to whether it is permissible, whether Chennai is correct or not.
Yes, Millets. Millets, as I submitted, Millets, my lords may kindly have that to be taken note of, that it is not any sort of subclassification, Millets. Because among the scheduled caste, Millets, in Tamil Nadu, there are 76 castes. And incidentally, these Arundhathiyas are treated as untouchables even by those other SC communities. This is the discrimination they have suffered.
Untouchables among the untouchables.
Yes, indeed, Millets. It's an established fact which even the commissioner, the learned single commission, has recorded. And they are also called Chandala, who have been in the leather industry, Millets. They are the cobblers, to put it simply, Millets. Now, Millets, my lords may kindly see. I just say, when it comes to Devendra Singh, Millets, para 35.
Defines Arundhathiyas to mean the caste Arundhathiya, Chakiliyan, Madari, Madiga, Pagdai, Toti, and Adi Andhra within the list of 76 scheduled castes.
Yes, Millets. There are 7 of them, Millets. And they have been completely marginalized. To this day, nothing has speculated to them. And I've just said, Millets, at the cost of repetition, they've been treated as untouchables among the untouchables. They don't have any social upliftment until this act came into force. And it's been founded on intelligence differentia. There's been a commission that has gone into, it has taken the social profile, and then it has concluded that. I don't think it offends.
What else do you have to say?
Millets, my Millets, when it comes to Devendra Singh, Millets, para 35 I rely on. Then Millets, Indra Sahani, I rely on paras 802 and 803.
Been read out actually. Just.
And finally, Millets, when it comes to Jainil Singh, para 27.
All right, thank you.
Great.
Yes, Mr. This.
3 problems with EV Chennaiya, as I want to place before your lordships, is the first one is that EV Chennaiya goes on the foundation.
Just one second, let's make a note of it.
Yes, my lords.
Shraddha Deshmukh.
My lords, I'm appearing in IA 26773023. This is the Karnataka Madar. 267730 of 2023. This is the Karnataka Madar Mahasabha, my lords. So the 3 problems, my lords, with EV Chennaiya, the first one is that it tackles scheduled caste as a homogeneous group. A lot of arguments have already preceded me about why it is not homogeneous because of its representation not being homogeneous in natures, there being diversity in occupation and the way they have been dealt with. I would like to deal with that part of homogeneity, which goes into the very definition and the structure of what forms scheduled caste. That is my first argument. The second argument is that EV Chennaiya in para 39 says that because the subclassification group affects only a minuscule proportion of the scheduled caste community, therefore it is not an exercise that they are willing to undertake at the moment. The argument of minuscule proportion has been well settled by legal tenets, my lords. I would place one of those judgments, my lords, wherein they have specifically held that when there is a right, there is a remedy, and it does not matter whether it is a minuscule proportion or a large.
Said in Navtej Johar also.
Navtej Singh Johar, my lords. And the last point, my lords, is that the judgment itself is in violation of the principles of constitutional morality, which has also been expounded in Navtej Johar and the judgments thereafter. Without taking much time, my lords, I would like to rely in my submissions, which is at compilation 1F, my lords. Compilation 1F at page 8, my lords. My lords have page 8, my lords.
1F, right?
1F, my lords.
Numbered page 8.
Yes, my lords. Number page 8, PDF page 12, my lords. I apologize.
PDF page 12, yes.
PDF page 12, my lords. This is an extract from the book Mark Galanter's Equating. In his book, Competing Equalities, Law and Backward Classes in India. And I have placed the book on record, my lords. I'm only extracting the portion that is relevant. At page 8, there was an interesting conversation when the constitution framers were deciding how to define scheduled caste, how to define untouchability. There was a conversation within them whether this is a term that could be defined at all. And I would read point number 2. The very different nature of the matter in the north from the south was brought out in the testimony before the Indian Franchise Commission, Mr. G.S. Pal, representing the United Provinces Hindu Backward Classes League, which had submitted a list of 115 castes estimated to make up over 60% of the population for inclusion as depressed classes in the United Provinces. Dr. Ambedkar asked a very interesting question. My point is this a list of what might be called backward communities, economically backward and educationally backwards? Or is this a list of castes which are called untouchables whose touch causes pollution? Is this the list of castes which are touchable but are educationally and economically backwards? Mr. Pal says this. I respectfully submit that this is a list of all the castes which in the opinion of the League are depressed classes. Untouchability in the sense in which it is understood in Madras or Bombay does not exist here. Bangi is the only caste that is universally untouchable, pollution by whose touch is regarded as something very undesirable. Here, untouchability exists, of course, but in a very mild form, or exists in some form or another in all the castes I've enumerated. Then Sir Surinder Singh Majithia asked, how would you then define depressed class of people? To which Mr. Pal responds, not in the sense of the definition by Bombay and Madras, but apparently here, the Hindu class is divided into high and low castes. The problem is very acute as untouchability is in Bombay and Madras. I applied 3 tests. The first is we are socially despised, then there is economic backwardness and educational bankruptcy. J.H. Hutton, which Gopal Shankar Nair, my senior, argued before this, wherein he talked about the different criteria that were put forward. 9 criteria were put forward by J.H. Hutton, wherein he said that are these people who will upper class Hindus will take water from? Will they be allowed access to public convenience? So he placed these 9 criteria before the committee. Then the report said this. The existence of multiple and ambiguous criteria permitted regional variation by giving the census superintendent scope for discretion. Each provincial superintendent was instructed to draw up his own list, taking these tests into account, and to reckon as depressed only those castes who definitely suffer from serious social and political handicap on account of their degraded position in the Hindu social scheme. The final reckoning then did not apply Hutton's test pure and simple. Excluded were some castes which were theoretically untouchable, but who by virtue of prosperity and vigorous organization have built up for themselves a strong position which obviates the need of any special measures for their social, political, or religious protection. Conversely, some groups were included even though theoretically they were untouchables.
They were not untouchables.
They were not untouchables. So therefore, even at that stage, the factors and the criteria that formed scheduled caste as a group, there was no consensus because India being such a varied country, it was not possible to define what exactly a scheduled caste can be. And that is the reason why, my lords, Constitution even today does not have a definition of scheduled caste. And the point is that the reason that the Constitution did not provide for subclassification is because originally, when the Constitution thought about bringing in reservation, it was to be only for a period of 10 or 15 years. They did not imagine that this reservation policy would extend to now over 60 years, about 75 years that the reservation policy has continued. So they imagined that it would have come to an end, so there would have been no need for subclassification. A judgment of this honorable court, my lords, that I've extracted at page 6, which is KC Vasant Kumar, it has already been read, but only one paragraph, which is at para 7, my lords. At page 7, PDF page 11, my lords. The bottom portion of it, my lords, which is the italicized and highlight portion. In fact, the upper caste of the same caste is verily accused of exploiting the lower strata of the same caste. It is therefore rightly argued that the basis of the caste system, namely purity and pollution, is slowly being displaced by the economic condition of the various segments of the same class. It is recognized on almost all hands that the important features of the caste structures are progressively suffering erosion. So what was originally understood to be a criteria for scheduled caste, which is purity and pollution, has itself eroded over a period of time and has become more economic in nature. So that's why, my lords, this is in terms of what is the factors of definition of scheduled caste itself. There is a very interesting article, my lords, which is placed at page 15, my lords, of my submissions, PDF page 15, running number 11. This article is called Heterogeneous Effect of the Indian Affirmative Action, the Role of Caste Certificates. I placed the article also on record. What this article says is that only by your inclusion of your name in the scheduled list, you don't automatically get the benefit as a scheduled caste. You need to get a caste certificate in order to enjoy the benefit as a scheduled caste. This article then goes on to study the different factors which will determine whether an individual will have access to that caste certificate and therefore enjoy the benefits of the caste certificate. One of the factors, they say, my lords, is the demand side factors. So they look at localities and communities where the parents of the person who's seeking the benefit has an employment, either in government employment, has education. If they have education and employment, they have found that such families have a 7.6% better chance of getting a caste certificate.
Yes.
The second factor is supply side, which is, I understand, my lord's time is less, that is the supply side, which is school. If I am from a locality where there is a primary or a secondary school, there is a 13% better chance of me getting a caste certificate and then enjoying the benefits. The third is procedural, which is if from my locality there are seats reserved for an MP or an MLA, there is a 9.2% better chance of me getting access to a caste certificate. And the lastly, which I found very amusing, was a community factor. They say that if these people live in a village along in a hybrid society where there are not just scheduled caste members, but also other members from other castes and communities, those people were going to have a higher benefit of getting a caste certificate versus somebody who was living in an exclusive area reserved only for scheduled caste. So therefore, my lords, even in the enjoyment of the benefits that accrue to a scheduled caste, there are so many different defining factors that scheduled caste as a group can never be homogeneous, and it always has to be understood as being a heterogeneous group. Coming to my second point, my lords, which is the minuscule argument. My lords may refer to page 23, my lords, of the PDF page 23, and the relevant page is at 24, my lords. I've extracted this from the judgment itself, para 39. My lords have para page 24. May I read, my lords, para 39? Legal constitutional policy enumerated in a statute must answer the test of Article 14 of the Constitution. Classification, whether permissible or not, must be judged on the touchstone of the object sought to be achieved. If the object of reservation is to take affirmative action in favor of a class which is socially, educationally, and economically backward, the state's jurisdiction, while exercising its executive or legislative function, is to decide as to what extent reservation should be made for them, either in public service or for obtaining admission in educational institutions. In our opinion, such a class cannot be subdivided so as to give more preference to a minuscule proportion of the scheduled caste in preference to other members of the same class. My lords, with due respect, I believe that this is an erroneous finding because, number one, in fact, there are reports which show that there are communities which have 70% representation in population, but have only 9% representation in education. So it's not really a minuscule proportion. But in any event, even if there were 5 people in a class of 50, even that minuscule proportions rights had to be addressed by the Honorable Court. And my lords, the paragraph is para 144, which is Navdeep Singh Johar, which is at PDF page 24, my lords, at the bottom. This is from the landmark judgment given by the Honorable Chief Justice in Puttaswamy, which has been extracted, my lords. May I read? Neither of the above reasons can be regarded as a valid constitutional basis for disregarding a claim based on privacy under Article 21 of the Constitution. That a minuscule fraction of the country's population constitutes lesbians, gays, bisexual, or transgenders, as observed in the judgment, is not a sustainable basis to deny the rights to privacy. The purpose of elevating certain rights to the stature of guaranteed fundamental rights is to insulate their exercise from the disdain of majorities, whether legislative or popular. The guarantee of constitutional rights does not depend upon their exercise being favorably regarded by majoritarian opinion. The test of popular acceptance does not furnish a valid basis to disregard rights which are conferred with the sanctity of constitutional protection. Discrete and insular minorities face grave dangers of discrimination for the simple reason that their views, beliefs, or way of life does not accord with the mainstream. Yet, in a democratic constitution founded on the rule of law, their rights are as sacred as those conferred on other citizens to protect their freedoms and liberties. Therefore, the argument that this affects only a minuscule proportion could not have been a foundation of this judgment. My lords, as far as the presidential list goes, my lords, Jarnail Singh, and I only want to mention the para number and not read it. Para 26 of Justice Nariman's judgment specifically says that even if we were to extend this to creamy layer and apply creamy layer to SCs and STs, even in that case, it does not affect or it does not have any embargo on the power of the president under Article 341 or 342. This is para 26, my lords.
At page 28,
Page 28, yes, my lords.
Yes.
So therefore, my lords, I'm not reading into this, but Justice Nariman, this constitution bench of this honorable court, has specifically said that by virtue of even including creamy layer, you don't have, it doesn't tinker with the presidential list under Article 341 or 342 of the Constitution. Para 741 of the Indira Sani has been read out, my lords, but the only point is that when they say that Article 61 is a right of equality, and 16.1 naturally includes the reasonable classifications under Article 14, 16.4, which is an exercise of classification, which is what Indira Sani says is 741, has to definitely bring about the exercise of reasonable classification. And the last point, my lords, which is the constitutional morality point, my lords. My lords may have the paragraphs from Chennaiya, which my learned seniors already read, para 41 and 113, where they pass the buck onto the state to do something more, rather than doing something themselves, despite understanding that the problem of subclassification exists and the need of the hour is to provide for it. It ignores the provisions, my lords. And page 30, my lords, at the bottom is Navtej Johar, my lords, where the doctrine of constitutional morality has been expounded. And the relevant page, my lords, is at page 31, my lords. This is an extract from Navtej Johar. Para 111, may I read with permission, my lords?
Yes.
Our constitution has often been described as transformative. One of the most important purposes of this transformation is to ensure that by realization of fundamental socioeconomic rights, people disadvantaged by their deprived social and economic circumstances become more capable of enjoying a life of dignity, freedom, and equality that lies at the heart of our constitutional democracy. It is the concept of constitutional morality which strives and urges the organs of the state to maintain such a heterogeneous fiber in the society, not just in the limited sense, but also in multifarious ways. It is the responsibility of all the three organs of the state to curb any propensity or proclivity of popular sentiment or majoritarianism. Any attempt to push and shove a homogeneous, uniform, consistent, and a standardized philosophy throughout the society would violate the principle of constitutional morality. And my argument, my lords, is that E.V. Chennaiya does the exact same. I'm extremely grateful, my lords, for the opportunity granted.
Yes, Mr. Khurshid.
Lords, grateful to Mr. Khanna. He's allowed me to come first. Lords, I would seek your lordship's reward in being for brevity. Lords, just two principles. I think a broad spectrum and the layout is there very clearly before your lordships. Lords, there are two strains that your lordships would examine. One is there's a strain of the difference between vertical reservations and horizontal reservations. This has been brought to your lordships. In horizontal reservations, there is no creation of a separate class. It is part of an existing class that the horizontal reservations come. So, my lords, so long it's a horizontal reservation, a new class would not be created. My lords, that's one argument. Mr. Khanna has given some submissions on that. My lords, I only want to add in my written submissions, I've said there are, if your lordships would open my written submissions at 1J, I've only indicated examples where women have been offered in given categories, women have been offered certain percentages, 33% and so on, including now reservations both in legislature and parliament. If your lordships will only note paragraph 2, where we've indicated the state of Tripura, where it has provided 6 categories in which women are given a share, and paragraph 3, where the state of Madhya Pradesh has given a share to women, which is about 33% or so. If your lordships would see above that, the 6 categories given, if your lordship will see women in the unreserved list, merit list, ST men and women in the merit list, ST women in the merit list, SC men and women in the merit list, and then SC women in the merit list. So within an existing category, horizontal reservations do not impact whatever is considered as the creation of a new category entirely. My lords, the other stream which your lordship will consider, and I do believe that this has not been placed before your lordships, is 341 creates a list. And your lordships will see 341 proviso talks about a list. And that list, if your lordship will see as 341 subsection 2, Parliament may by law include or exclude from the list of scheduled castes specific in a notification issued under so-and-so. So you can delete or include, but include in a list. My lords, my submission is the list is not the class. Every entry in the list is a class. Every entry in the list is a class. And so between 2 entries in the list, there could be competition where distributional justice and equity between those 2 classes are what your lordships can examine, and that would not fall foul of the 341 and the president's power. Well, that's my submission. For this, my lords, your lordships will understand, as always, I have put in an article of Ronald Dworkin on what is equality, distributional aspects of equality and welfare aspects of equality, including the vision that we come across in the works of Mr. Amartya Sen. Well, that's all I want to say, and I hope I have met your lordship's demand of brevity. I'm grateful, lordship.
Yes, Mr.
Lordship would give me a minute also, my lord.
Kindly have, my lord, my written submissions at page 217, volume 1, my lord.
Which volume?
Volume 1, my lord. PDF page 217, my lord. Lord, partly my senior colleague, Mr. Khurshid, touched that point. But, my lord, 2 points I want to raise, my lord, they have not been touched. One is, if your lordship will be kind enough to have it 217, my lord, the first 3 points I have raised, my lord, for consideration of this constitution bench, my lord.
Volume 1, page
217 PDF, my lord. The written submission starts, my lord. The first 3 issues I have flagged, my lord. Other issues I am not, my lord, repeating. Whether the subclassification or subdivision of SC/ST declared in the state under Article 341 is permissible under Article 16(4) of the Constitution in order to give them adequate representation in the service under state. In other words, whether the horizontal reservations cutting across the extent provision of the vertical reservation in SC/ST in a state is innately intra-vires the Constitution of India or not. Second, my lord, I am requesting your lordship to consider is whether SC/ST is duly recognized under 340, 341 and 41(2) of the Constitution of India on the basis of the statistical data, and yet their representation in the state services can cogently be given proportionate preferential treatment so as to provide them adequate representation in the such services under the state or not. Third point, my lord, on Article 14 has been, my lord, flagged by my previous colleagues. My lord, I will only request, my lord, to kindly state we have, my lord, para 7. I'll just not read para 7 and 8, my lord, where I have, my lord, the golden thread principle and, my lord, Maneka Gandhi, my lord, that Article 14, that it's a part of the body, they can't be. Kindly have, my lord, para 19, state way, my lord. Lord, these are the 2 paragraphs which have not been placed before your lordship from Indira Sahni, my lord. And I say, my lord, in para 38 of the Chinaya, the lordships have, my lord, missed these 2 paragraphs which were the crux of the judgment.
Para 514, my lord, it is necessary to add here a word about the reservation for women. Clause 2 of Article 16 bars the reservation in the service on the ground of sex. Article 15.3 cannot save the situation since all the reservations in the service under the state can only be made under Article 16. Furthermore, the women come from both backward and forward classes. If the reservations are kept for the women as a class under 16.1, the same inequities phenomena will emerge. The women from the advanced class will secure all the posts, leaving those from the backward classes without any. It will amount to indirectly providing statutory reservation for the advanced classes as such, which is impermissible under any of the provisions of the Article 16. However, there is no doubt that the women are vulnerable section of the society, whatever the strata to which they belong. They are more disadvantaged than the men in their own social castes. Para 812, my lord, where your lordships have said, we are also of the opinion that this rule of 50% applies only to the reservations in favor of the backward classes made under Article 16.4. A little clarification is in order at this juncture. All reservations are not of the same nature. There are two types of reservations which may, for the sake of convenience, be referred to as vertical reservations and horizontal reservations. The reservations in favor of the scheduled caste, scheduled tribe, and other backward classes under Article 16.4 may be called vertical reservation. Whereas the reservation in favor of the physically handicapped under Clause 1 of Article 16 can be referred to as horizontal reservation. Horizontal reservation cut across the vertical reservation, what is called as interlocking reservation. To be more precise, suppose 3% vacancies are reserved in favor of the physically handicapped person. This would be reservation relatable to Clause 1 of Article 16. The persons selected against this quota will be placed in the quota by making the necessary adjustment. Even after providing for these horizontal reservations, the percentage of reservation in favor of the backward classes of citizens remains and should remain the same. This is how the reservations are worked out in several states, and there is no reason not to continue this procedure.
We say in Marathi must.
My lord, only para 21 and 22. My lord, in 21, my lord, I have said, my lord, under Article 343D and 343T, my lord, your lordships have, I'm sorry, 243D and 243T, your lordships have, my lord, noticed that it is the horizontal reservation which is recognized by the Constitution. So therefore, my lord, subclassification as a concept has been recognized in the Constitution in 1992 when they have provided, my lord, for reservation within reservation. That is, my lord, I have extracted in last 4 lines of para 21, Article 343D2, my lord, which reads, not less than 1/3 of the total number of seats reserved in Clause 1 shall be reserved for women belonging to SC and or, as the case may be, scheduled tribe. Thus, the subclassification has been envisaged in the Indian Constitution. I'm sorry.
Women come in a horizontal reservation, so at the most it will be interlocking of horizontal reservation with that of vertical.
No, my lord, that is what they lot in Indira Thani.
Indira Thani also they say that there could be a reservation for women.
No, in Indira Thani, your lordships have said that these are the vertical reservation for SC, ST, backward, and other classes. And in horizontal reservation, you can provide for different categories. This is what, my lord, your lordship will be now providing for, my lord, in this judgment.
Right. Thank you, Mr. Rakesh.
I'm great.
Thank you.
Lordship, volume 1, page number 104. Only 2 minutes, sir.
Yes.
Volume 1, page number 104. Last 2 lines. My humble submission is that for the upliftment, there can be subcategory, under category of SC, ST reservation. But that cannot be done by the state legislature. It can be done by only the Union Parliament. And for it, only 2 logics. I have.
You on this side or this side?
Sir, let me say the partly this side and partly that side.
No. Hybrid.
Sir, let me say of the 2.
Neither here nor there.
Sir, for
Then
the.
it should have been somewhere between Mr. Meshram and Mr.
Yeah, yes,
Mishra. You are right.
I am assisting
Towards
the
the
court to
advocate
reach
general.
the, sir, I am assisting the court to reach the right
So you
conclusion.
are you contending that the Punjab Act is unconstitutional?
Yeah,
Because according to it can only be done by Parliament.
yeah,
Then,
absolutely.
then,
And
then let the arguments on this
for
side be over.
logic.
But you know
For
what?
to logic.
Why are you preempting their arguments? Acha, what do you want to say all that?
Yes, sir, please, sir, it's the request. The interplay of Article 15.4, 16.4, 341 and 342 is not giving power to subcategorization to the state legislature. And second one, the original of the scheduled caste, going back to the Pune Pact, when the it is between the Gandhiji and the Baba Sahib Bhimrao Ambedkar, and it have its origin to the movement for the reservation of the depressed class in the state legislature of that time. And this scheme got the space in the Government of India Act 1935. Scheduled caste is class.
You have opened the batting for the respondents. Yes. But the captain of the respondents has to decide who will open the
Because
batting.
my name is included in the list of this side. Sir, let me say my name is included in the list of this side and it is, so that's why.
All right. Mr.
Sir,
Mishra.
Let me complete one point, sir. One point. Only, sir, one point. Scheduled caste is a class, is a group of classes, origin to untouchability, not to the backwardness, sir. Because, sir, the list of the petitioner side included my name as an intervener in the state of Punjab versus Davinder Singh. Yeah. Client is a private party, sir. Being the citizen of India, it is the
In which petition?
item number 701, sir.
So who's the client?
Who is the client? Intervener or
It is Miss Sela Sharma. Miss Sela Sharma.
Ms. Shaila Sharma?
Yeah.
So she is belonging to any reserved category?
Kya, pardon?
Is she belonging to any reserved category?
No, sir, it is the question bench matter and it affects the society in the long run. So that's why.
Anybody can come and.
Yes, yes. This is a court. That surname with Ms. Shaila Sharma bears with you, the commonality. Is there any other link? I mean.
No, sir, it is
Different
just the
Sharma.
client and it is the
All right.
nothing more.
That's all. Thank you. Mr. Luthra, and then we'll come back to you.
No, sir. So that's fine. That's fine.
Just take 4 to 5 minutes and.
Yes.
Okay, thank you.
Want to go first? Your Lordships, much has been argued. I'll restrict my argument to one aspect which has only been alluded to, and I'll just take about 4 to 5 minutes because I'm conscious of the time limitation that this.
What is the argument that you're making?
Your Lordship, the core argument which I'm advancing is that about intersectionality. This is the argument of intersectionality which was briefly alluded to by Mr. Farasat and Mr. Shankaranayan while dealing with Patambali Jali talked about this case, talked about this proposition, Your Lordship. My argument restricts itself to this aspect on why intersectionality or intersectional discrimination would be at the core of this and would assist Your Lordships in arriving at the conclusion that Chennaiya has been wrongly decided and therefore it requires a revisit. Before that, Your Lordship, just to give a matter of context to this, Your Lordship, this issue first arose in the case of Chebrolu while Justice Arun Mishra and the 5-judge bench of 100% reservation was deciding the issue. And then as a matter of obiter, it was opined that the scheduled caste and the scheduled tribe list under 341 may require a revisitation. That in 2020 April was followed by the 5-judge bench decision, which Your Lordships are now sitting in reference of. In Devinder Singh, it therefore requested Your Lordships to have a revisit on the issue of why Chennaiya's decision is wrong. And therefore, Your Lordships are now called upon in the 7-judge composition to decide the correctness of it. My argument on intersectionality, Your Lordships, is that there can be an overlap between the pre-existing discriminations that exist and the effect of this pre-existing discriminations would affect some parties or some groups or some classes and some castes to a far greater extent than it would affect the others, Your Lordships. In this regard, the only case which I would like to cite, and it follows then in sequence, is Vikas Kumar versus UPSC, Your Lordships, 2021. Now there, Your Lordships, what has already been argued in extenso is the concept of substantive equality. And Your Lordships, while deciding the concept of substantive equality, thought it proper that substantive equality must now be extended to reasonable differentiation and for specific measures in both regards. This aspect, which was there, your lordships, has then been extended to which Mr. Shankara Narayanan already talked about in Patam Jamal Bali, your lordships, of 2021. Now, your lordships, when the state acknowledges intersectionality in this regard, then the most potent tool to remedy the difficulties which are faced by the most disadvantaged and the most oppressed becomes subclassification.
Yes.
And therefore, your lordships, when subclassification comes about, the fountainhead of powers, as has already been argued, is 15.4 and 16.4. So the source of power is available. There is no constitutional embargo as such, because Indira Sahani itself, and that has again been argued in extenso, speaks about the fact that backward classes will be read in a manner which will not exclude the others, your lordship. So since that has been argued in extenso, what I would only urge your lordships to keep in mind, and this again, I'm sorry that if there is some amount of overlap and repetition, is that the Constitution itself is transformative in its character and it needs to be interpreted in a dynamic manner. The static nature of interpretation, as was argued, if it is accepted, will lead to fossilization. The difficulty in that regard, which then arises, your lordships, is that because there are competing groups, competing castes within the same category, until and unless subclassification is permitted as a tool, there will be internal contradictions, and that leads to a net negative and therefore inefficiency, your lordships. In this regard, may I just extend the argument to just one more line, and then I'll rest, your lordships. Your lordships realize that in case there is no transformative nature which is accepted and there is fossilization, then even EWS reservation, which came up as a 5-judge combination decision, your lordships, there was an acknowledgement that until and unless the state is allowed to identify the excesses of disadvantages and thereafter move upon towards utilizing tools that remediate, there cannot be an effective solution to the issue at hand. And therefore, in the present situation, your lordships, the advantage which is derived out of subclassification is that it moves ahead with time, it addresses the competing concerns, and the state, being the best possible agency to utilize all its superior resources to identify who are the most disadvantaged through this idea of intersectionality, is best equipped to address them, and the tool available is that of subclassification.
Thank you.
Grateful, your lordships.
Mr. Luthra.
I have just two things to say, because everything has been said. But I represent the state of Telangana, and the original legislation applied to the combined state in Andhra Pradesh, which was struck down not in Chennai. For us, we believe not that subclassification is essential, and therefore we support the petitioner's prayer in writ petition civil 562 of 2022. Secondly, Lord, the point that is sought to be made is, insofar as Madigas are concerned, there is a 70%, and I'm sorry, Lord, I've come in very late into the matter. I'll give your lordship a 2 or 3 page note with the numbers. There's a 70% Madiga population in Telangana, and the benefits to that are only 20% of the entire reservation. So it's completely disparate the way it is being done, and that has to be rectified.
70% of the population in Telangana is Madiga.
No, not 70% of the reserve, amongst the reserve category is, not 70% among the reserve category is Madigas, and they're only getting 20% of the benefits. Now, that being the position, there becomes a situation where we are totally handicapped in ensuring that benefits reach the last mile to the actual intended beneficiaries. And that's the concern of the state. This was considered. And my lord, we just note the page numbers of the Usha Mehra committee. The Usha Mehra committee, my lord, notes this issue at pages 437 and 438 of the report of that petition, lord. It's there as part of the petition. And also notes, lord, the other aspect that it's not a homogeneous entity at 419, 420, but lord, 437, 438 is important. My submission is really this, lord. My learned friends have said earlier, it can't be a static exercise. I will only add this note. We cannot have a situation where states are disabled from providing the benefits of reservation to the persons who deserve them most within the community. That's the short issue I had to say, Lord. I'm most grateful for your lordship's indulgence. We'll give a short note, Lord. If my Lord may give me that liberty to give a short note with the numbers. But I,
You're for the other side, Ms. Mishra? Who, sorry. Yes, yes, sorry. Who else now on this side remain?
We should be on that side.
Can I address your lordship for 5 minutes, my lord?
not just to give a note, that liberty may be granted because we've come in late into the change in standing council.
On this side, my lord, can I have 2 minutes, my lord?
All right, Mr. Ansaria, what is it that you want to say on this side?
My lord, I'm sorry, my written submission circulated late. My lord, may I just only point out to your lordship, my lord, the constitution has been amended, my lord, on the issue of reservation from first constitutional amendment to the 105th constitutional amendment on 9 occasions only on the issue of reservation. I have given the details, my lord, on pages 1, 7 and 8. Page 7 and 8 of my written submissions. I appear for the petitioner, my lord, in the transfer petition 464 of 2015 for Arun Thetiyars. I am one of the Arun Thetiyars, my lord.
Yes.
My lord, the constitution has been amended on 8 occasions out of 9 occasions on the reservation issue only to overcome the decisions of this honorable court. The reason why I'm saying it, and it's important, my lord, that your lordship, while considering the constitutional interpretation, takes into account that the constitution is a living instrument. It is an organic document and cannot be frozen. Unfortunately, my lord, on all 8 occasions, my lord, where the parliament is to overcome the decisions, my lord, the courts have
Mr. Ansaria, does that mean that therefore the fact that the constitution was not amended after Chinaya is an indicator that the parliament did accept Chinaya, right?
No, my lord, parliament is, my lord, all these reports have been, my lord, that it should be amended. And your lordships have been considering this issue, my lord, since 2009. The act is there already, my lord. So far Tamil Nadu is concerned, 2009 act is there. It has not been state. We are getting benefits out of that state for last 14 years, my lord. So the parliament, maybe, my lord, there are reports which are saying, my lord, the parliament is awaiting the decision of this honorable court because Devender Singh was already there, my lord, and that is referred.
Thank you, Mr. Ansaria. Thank you very much.
There's one more submission only, my lord, it is, Lord, if the courts by creamy layer principle can exclude, my lord, a category of persons from the benefit of, my lord,
that point has been made already.
Yeah, that point has been made. The parliament and legislature can definitely give an accelerated benefit to a category of persons, my lord. It cannot be deprived of giving an accelerated benefit. Lordship may only note, my lord, page 7 and 8, my lord. I have given the details of the amendments which are there, my lord, in my written submission.
Okay.
And the details are there.
Tomorrow now, who will open the arguments from your side?
I appeal for the state of Andhra Pradesh.
State of Haryana.
Yes, Dr. Muralidhar, yes.
Yes, I appeal for the state of Andhra Pradesh. My instructions are that after Chinaya, we have not continued with the subclassification as far as providing reservations are concerned. And we abide by the judgment of this court, which will now be delivered.
All right.
Thanks.
State of Andhra Pradesh. So tomorrow now, who will be opening?
Learned friend is for this, just 1 minute.
Within 4 minutes, because I will not take time. I am representing Haryana. My notification and act are under challenge, where we have also, the similar act like in Punjab. And my submission only are one, that 16(4) actually permits the state to go to that extent of tinkering with the list of 361. Why, because
you are arguing something everybody has argued that it does not amount to
yes,
tinkering.
that doesn't amount to tinkering at all.
If you argue this, then
you're virtually destroying the case of the other states.
You are washing away their 2 days efforts.
I mean, that exactly to the contrary that Punjab has argued, Telangana has argued, Andhra, I mean, everybody has argued to the contrary.
Punjab says, we are not tinkering. I say,
that you can tinker.
I say 16(4) says we have to see inadequate representation. For that, we have to conduct the data collection.
You can't tinker with the 341 list. The moment you concede that, you're in deep water.
I say that we make reservations for those who are inadequately represented. For which we have to collect the data. And the data has to be collected in the granular extent, to the deepest extent. And therefore, I say that providing for reservations. Therefore, 16(4) Chennaiya has used that word tinkering, my lord. Chennaiya uses that word tinkering. I say, my lord, 16(4) gives power to the state to, my lords, make reservations for those inadequately represented. That is one. Number two, my lord, was a question which fell from my lord, whether single caste could be reserved, my lord. Now, my lords, municipal committee of a small area, my lord. The municipal committee of a small area, small territorial jurisdiction may have 2 castes, 3 castes living within it is state, my lord. Now, using 16(4), municipal committee, my lord, of that small area can, my lords, make reservations, provide for reservations using 16(4).
So the municipal council has an independent power to make reservation.
That state, my lord, it is covered by the definition of state. And number 3, my lords, Thank you, Mr.
Thank you. Bijay?
My lord, sir, I need only.
There's one last thing, my lord. RC, reverse case, my lord, in
Item 11, you're late.
Para 70 Act committee, my lord, that under inclusiveness, in para 70.
All right, we'll consider that.
My lord, I need only 1 or 2 minutes, ma'am.
So you have it right now.
Lords, before my learned friend begins, I'm challenging the order. My arguments before the Chinnaiya bench are recorded in para 9, saying Chinnaiya needs to be revisited. Lords, now I'm not advancing, probably taking up your lordship's time with any oral argument. I'm appearing in item 11, which is civil appeal number 5586 of 2010. The appellant is Haryana Dhanak Seva Samiti. I appear for him. All that I'm saying is this, Lord. In view of the submission made just before lunch by the learned solicitor on behalf of the Union of India, that even if grouping is done by the state, it will have to run the gauntlet of 338 and 341.
Yes.
On that, I may be permitted to file a written submission. Sir. That's all, my son.
My lord, sir.
To assist your lord.
I just want to say this much only, my lords. What I submitted as the first layer of my arguments in the EWS, my lord, is very may kindly recollect. The facts. And my lords, the facts is extremely important. Ground H of the civil appeal is the crux of this particular matter. Ground H. And therefore, my lords, accordingly, I have an effective research. I got some judgments from other countries also, whether subclassification is possible. And due to this subclassification,
why don't you give us the list of the judgments?
So I will, yes, that's what I am coming.
Give us a written.
That's what I will give you 2 pages notes. Okay. And I don't want to go further.
Thank you very much.
Thank you.
Let's hear me for a couple of minutes.
Yes, Kanu.
Malas, I've put everything on a 1-pager so that I don't have to take Malas through anything. Malas just accepts it. I have also served it to the court master. The 2 short points that I seek to make, I'm not going into the distinction between 341 and Article 16. The distinction, according to me, lies at a more doctrinal level. The distinction lies at the policy level. The state, when it takes the decision of providing affirmative action, has 2 questions before it. The first question is who to provide affirmative action to. The second question is how to provide affirmative action to. The question of who to provide affirmative action to is generally answered through the process of what Indra Sahni calls underlying factors. Those underlying factors in different societies may be social, educational, they may be caste-based, they may be economic, they may even be racial. In another society, it may even be racial. So that is the process of identification. It is the next sequential process on how to provide affirmative action is where Article 15 and other articles kick in. The question of how to provide affirmation, how to provide affirmative action includes the areas of operation in which affirmative action is to be given, the manner in which it is to be given, and the extent in which it is to be given. The question of subclassification, my lords, in my humble submission, falls under the policy choice of the manner and the extent. It does not fall in the first question of identification. If my lords looks at the universe of reservations or affirmative action in the country, this subclassification is relevant purely from a policy point of view because there is a universe that today starts from the right to education under 21A. That is education till the level of 14 years. Thereafter, it is in the higher education under Article 15. Thereafter, it is at the services level. Thereafter, it is also in reservation in promotion. However, it is only provided to a specific class, that is the scheduled caste and scheduled tribes and not others. There is also political reservation, right from the panchayat level now today all the way up to the parliament. There is political reservation for SCs, OBCs, SC, STs and women. So therefore, there are different zones of affirmative action, and the state needs to exercise this policy malleability. And it is this subclassification that will allow the policy malleability. This malleability should not be hindered by superimposing the limitation of 341.
Same line of argument.
Please,
You have sort of conceptualized.
the second is a note of caution I just wanted to flag. So my humble submission is that certainly diversity is not antithetical to efficiency. However, diversity is a small subset of efficiency. There are other objective factors that color the definition and the meaning of what efficiency stands for. There has been a development, what the learned solicitor said, that in the cauldron of change of equality laws in the country, there has been development. The judgments post Nagaraj in Jarnail and recently in the Maratha reservation case have referred to these factors of efficiency as controlling factors. And therefore, it is not an ipso facto position that diversity itself is to mean efficiency. As these are my short submissions.
Thank you. Thank you.
Now tomorrow. Higher number.
Now respond.
9345920 in the application.
All right. Thank you.
Maybe take it up.
Yes. Now tomorrow, who will commence the
Start. Judgment. Yes.
So it's three of you who will be. No. Now today this side is completely over. You just want us to take it on the record, is it?
I want to.
Record pe rakh lijiye aap.
I want to place foreign judgment tomorrow. Only.
Place it on record.
You place it, place.
Please applicate. From this side, not the transfer petition, it is pending because the Tamil Nadu government totally
Foreign judgment.
Whatever is pending, it will be governed by what we decide on the correctness of Chennai.
The transfer is admitted, not allowed.
That's all right. Once Chennai, the correctness of Chennai is decided, everything else will follow then.
Correct.
Mr. Saurabh, you will have to reapportion the timings amongst yourself.
Right. So, if you can, the three of you,
Yes.
if you can take, say, 45 minutes, 45 minutes, 45 minutes.
Manoj, at least 2 hours required, initial, because readings are required.
The two of you will finish in about 1 hour, right? All right, fair enough. So, say 10:30 we start, 11:30, 12:30, and you finish by 1 o'clock. We'll give you half an hour after that.
At least
Don't
one day.
So, Mr. Sarup, don't confuse numbers with volume, or volume with substance. So you just, that's why we said we give you that time. Chaman Lal ji, aap file kar lijiye.